All right, counsel, you've each received a photocopy of the court's ruling regarding requests for discovery sanctions. My apologies to counsel for the court's failure to fax you a copy earlier than today. I experienced a complete breakdown of my fax program. At home, I attempted to fax this to all parties yesterday and was apparently obviously not able to do so. If the parties wish, I'll give them leave to review the ruling, and I would, court's ruling asks for input from both parties regarding opening statements and the jury instruction.
Yes, I read it.
All right. Ms. Clark?
We'd like the opportunity to review it more carefully, Your Honor. There are a number of items that I'd like to take up with the court and have an opportunity to confer with co-counsel concerning the court's ruling.
All right. How much time do you think you need?
I would like at least until 1:30 to address these matters.
Well, Ms. Clark, let me tell you what I think the two issues are that we need to resolve this morning. You've seen the court's ruling and the court's proposed jury instruction to the jury to disregard opening statement comments regarding the witnesses that are listed on page 4. This is significantly different than the instruction that you requested. You requested an instruction directing the jury to disregard the comments of counsel. I think that is overbroad, and I think the only remedy is to mention or to ask the jury to disregard defense counsel's reference to these particular witnesses, or if there are any others you feel that have been mentioned in the record that whose mention was inappropriate.
I don't appreciate that for the
All right. Do you agree with the list that the court has taken from the record?
That's the only, with respect to this area, I was reviewing the transcript last night, and I thought that there were more references to other witnesses.
Well, that's why I asked for a draft. I asked both sides for a proposed instruction because I was seeking particularity with regards to the court's instruction to the jury. This is the list that I have here on page 4 as a result of my going through the record line by line, noting where these persons had been mentioned and then comparing with the witness lists that have previously been disclosed.
I'd like to hear
Oh, certainly, Mr. Kirk. Sure.
There are certain notable witnesses who are not mentioned that we specifically delineated to the court when we were last in session. Expert witnesses promised by the defense, although not by name, who have never even been disclosed by name to the prosecution, such as an expert in tire tracks, an expert in shoe prints, an expert on finger cuts, an expert on rheumatoid arthritis. None of these have even been named to us. And then again, the statements made by counsel concerning alleged conclusions drawn by experts Dr. Bodden and Dr. Lee. We have no reports. We have no idea what counsel intends to present in the way of their testimony, having had no discovery. So there are many more that I would add to this list, and that the court is aware were not disclosed to the prosecution in any way, shape, or form.
All right. Well, you'll notice that the court's order includes those specific persons, and I make reference to the transcript where certain expert testimony is mentioned, and it includes the ones that you've just listed now. And I think that the requirement at this point is that they be disclosed, since obviously there has been indicated an intention to call those persons as witnesses.
Where does the court indicate to the jury that those experts have been...
No, we're not there yet. Flip back to page 2, where we start with the section on expert witnesses. All right, first full paragraph after the quotation from the code section. There's an order from the court directing disclosure of these persons, reports, et cetera, and in addition, other experts mentioned by defense counsel at these particular places in the transcript, which include the ones that you've just mentioned.
Is this part of what the court proposes to say to the jury?
No, because I think what I need to do is first determine who these people are, because they may be persons already disclosed to you. But I'm concerned, my concern here is also the reports.
Then we have another
If the people were not mentioned by name to the jury in opening statement, those witnesses, the people are not aware of who these experts might be, even
But
by
Ms.
name.
Clark, if you read the first sentence, it says the defense is therefore ordered to immediately disclose, blah, 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 and the identities of these persons.
I'm aware of that, Your Honor, and all
All
I'm
right,
saying
so I
is
assume that that's going to happen today. Now, after you've had the opportunity to find out who those people are, then you can make your judgment as to whether or not they should be included in the court's instruction to the jury.
Then I'm unable at this time to indicate to the court what the people's position with respect to this ruling, because there's information we still don't have.
Well, it's a ruling. After you've had the opportunity to look that over, I'm going to proceed today. My inclination is to instruct the jury, as I've indicated today, and to move on with the case. And if it comes to light that there's something else, I can always re-instruct the jury as to other particulars.
So there's already an indication there are other witnesses that have not been disclosed to us by virtue of counsel's opening statement concerning those experts.
We don't know that yet.
I'm
I have
telling
the
you.
suspicion that the tire track person is probably Dr. Lee.
Well, a suspicion is certainly nothing that we can
Your
call
Honor, so
discovery, Your
here's
Honor.
suspicion, it's Dr. Henry.
Well, thank you very much. I finally hear this today, this morning. That people are entitled to discovery, Your Honor, not an assumption and not a suspicion.
We give a Dr.
We haven't been
Hold on.
told anything.
Hold
We
on.
haven't seen a report.
All right, I agree. And Ms. Clark, that's why I've ordered its immediate disclosure, which means today.
And I appreciate that, Your Honor. I really do. But I'm asking for the court to inform the jury that we were not informed of any of that either. That should have been disclosed to us as well, not just these witnesses, but the experts and what they were going to testify to. Why do we find out only in opening statement that Mr. Cochran intends to call these expert witnesses to testify to various things of which we had no knowledge? The code requires them to do so. Those experts that he mentioned in his opening statement, for which we had no discovery, and only now, based on the court's stated suspicion, do we hear that that's who is going to testify to what he represented to the jury for the first time ever when we heard it. That's a blatant violation as well. We were entitled to know about that.
Hold on.
just as
Mr. Cochran, you'll have the opportunity to respond.
We were entitled to know about those witnesses, just as we were entitled to know about the witnesses listed by the court in this order. That's why I'm asking for the court to include them in the order. Why would they be any different?
All right, let me ask you another question. What is your position on your request to reopen at this time?
The people strenuously urge the court to allow us to reopen. I will cite to the court the civil case that I brought down to court the other day. Unless the court already has it through Lexis, but it does authorize the reopening of opening statement. I'd like for the court to see that, and we would like to reopen. The court has requested a proffer as to what we would address in the opening
Yes.
statement, and we will, until Mr. Cochran completes the opening statement, we're not going to know the entirety of it, because although it's been represented to us we got told complete discovery, we obviously do not. And I know that other surprises are going to be forthcoming from Mr. Cochran, so I can't give a complete proffer as to what we would state at this time.
Well, as to the individuals who are listed in the court's proposed instruction, as to those listed individuals, what is your proffer?
Well, we don't have a statement yet from Michelle. We don't have a statement from Mark Partridge. We don't have a statement from Howard Weitzman. We don't have a statement from Skip Taft. We don't have a statement from Christian Reichardt. We still don't have discovery of that. And in order to know exactly what I'm going to say in response, I need to have a statement.
My recollection is that is a list of people whose statements were belatedly given to you and/or... Yes, those statements were given to you, albeit at the close of business after the first day of opening statements by the defense.
No, Your Honor, we have never received a statement for Michelle. Mark Partridge, I believe there's a one-paragraph representation that he spoke to defense counsel, but no particulars as to what he said. Howard Weitzman, we have no statement. Skip Taft, no statement. Christian Reichardt, no statement. There's only one witness here for which we really have a statement, that's Marianne Gerges. And we are putting together our proffer as to her at this time. I believe that Mr. Darden will be bringing it down with him.
May I respond to this situation?
Well, hold on just a minute, Mr. Cochran. I just wanted to settle
All right, sure.
where we are at this point. All right, Mr. Cochran.
Yes, Your Honor.
Good morning, sir.
Good morning, Your Honor. I just got Your Honor's order this morning, a proposed order, and we've had a chance to review it. I'd like to, first of all, turn our attention to the list of witnesses that the court proposes to tell the jury about in the jury instructions, which I think is the heart of Your Honor's proposed order, obviously. With regard to Marianne Gerches, Mr. Douglas has indicated that, and our position is and will always be and absolutely is, that when I read the name Marianne Gerches, I believe that statement had been turned over. It, in fact, hadn't, and we indicated that. With regard to Michelle Abduram, there is no statement. With regard to Mark Partridge, the prosecution, Your Honor, had, in fact, been given a portion of his statement. In fact, in a letter that he wrote after a memo where he's a lawyer, as the court is aware, when we returned back to Chicago, if I recall, and I'll try to find this, Mr. Partridge wrote a letter detailing his observations of Mr. Simpson and sent a copy to the prosecution and to the defense. Mr. Douglas turned over another 2 pages, I think, afterwards. They'd already been notified of Mr. Partridge and had an earlier statement, and I believe they also had his lengthy memo about what had taken place. With regard to Howard Weitzman, Skip Taft, there are no statements. These are both lawyers, and we tried to explain that to the court. There are no statements. It's no subterfuge. If the court is aware of the relationship we would have with Skip Taft, a business lawyer that we talk to on a daily basis, there's no report.
Well, the problem, Mr. Cochran, is that neither of these persons appear on your witness list.
But and I appreciate that, but I'm saying there is no report regarding those two. With regard to Christian Reichard...
But the fact that they were not placed on the witness list, there's no notification to the other side that they're going to be witnesses, that's the problem.
All right, and I understand that. I've indicated to the court that's through inadvertence, and I understand Your Honor's sanction on that. With regard to Christian Reichard, they have interviewed Christian Reichard at length. He's on the list, interviewed him at length with Dominic Rubalcava, the lawyer. There's a transcript of that effect, I believe. And we have no statement. We have no report from Christian Reichard. So I guess what I'm asking the court with regard to Reichard, I don't understand where the prejudice is. We have no report. They know about him. He's Faye Resnick's former fiancé. You heard what Mr. Darden said. You know, and it's very interesting, Your Honor, how Mr. Darden could immediately make some statement maligning Christian Reichard when he knows everything about him. Or for instance, with regard to Marianne Gerches, when they heard the name, it seems as though they'd already known about her. And the court will recall that with regard to Marianne Gerches, this is not to obviate whatever you feel is proper. I'm prepared to go forward and argue. Marianne Gerches had tried to contact the district attorney's office. The court should read that statement. She not only talked to Patty Fairbanks in the DA's office, she puts in the statement, if I recall, the phone number in the district attorney's office that she called.
Mr. Cochran, though, that's dancing around the issue.
All right.
The issue is, was this person named as a witness by the defense?
No,
and
she
were
was
the
not.
statements in your possession turned over prior to trial? The answer to that question
She
is
was
no.
named. She was named, I believe, but the statement was not turned over, as I've indicated to the court. But
That's
I wanted
a violation of the discovery rule.
Okay, and I appreciate that, Your Honor, but I thought the court should have all the facts. And I think what it does, it goes to the state of mind, our state of mind. Your Honor, and I'd just like to say this again. No way in the world, why in the world would we want to withhold witnesses from them that you could possibly preclude down the road? It's not going to do anything to damage Mr. Simpson. And the effort of this is a massive volume of work, is not an excuse. We want to get this case underway. We're not going to do anything to harm that. We want to try the case. We're the ones who've not waived time and want to get it forward. We understand we have to all abide by the rules, and we accept that. The other thing I think that the court should listen to is that this violation in the jury instruction, proposed jury instruction, the court proposes this was violation of the law and the cause of the 2-day delay. Well, that's not completely correct, because as you indicate later, the part of the cause of the delay was the illness of D.A. William Hodgman. So I think the court needs to modify that in some way so it more accurately reflects the facts. If that was the only cause, we perhaps could have argued on Friday or whatever. So I think that I would ask the court to consider that. With regard to the experts, we will comply wherever possible, Your Honor. We do not have reports yet, because much of the reason we don't have reports, Your Honor, is because our experts have not been able to actually examine the evidence. We're making a motion to that effect. To be able to examine this evidence in their lab, they can then make the report. We know generally from their observations, what they're going to say. And for counsel to say that they didn't know about Drs. Batten and Drs. Lee, and Dr. Lee and Dr. Wolf were out here the week of June 12th, Your Honor, the court is aware. The other thing is, as the court correctly points out, in this reopening of the opening statement, it is illogical at best, and I think it's going to be confusing at worst, to allow them to reopen to talk about Mary Ann Gertjes from that standpoint. I think that if you admonish the jury to disregard it, then they get up and then talk about her. That doesn't make any sense, Your Honor. Then do I get a chance to respond to what they have to say? Your Honor, what's happened in this courtroom is they have continually maligned witnesses, and that is an intimidating effect, and that is wrong. And so while we're talking about the defense, let's talk about them. Over this weekend, every one of these witnesses who were maligned by Mr. Darden now have lawyers. Mary Ann Gertjes, Christian Reichart, Ron Fishman, and Rosa Lopez.
Your Honor, I object to this. None of this
Hold on,
is
Ms.
responsive.
Clark, Ms. Clark, please.
None of this is responsive to the court's
I'm
question.
going to instruct counsel not to interrupt other counsel's statement. This court is more than patient. I allow each side to completely say what it is they want to say. I'm not going to tolerate any more interruptions by counsel from either side. That's a warning to all counsel. Next violation will be dealt with by sanctions,
Thank you.
including contempt.
May I proceed?
Please.
Thank you. Your Honor, what I was trying to say was that I think that it's totally improper to do those things under the because it has an effect on these witnesses, and I think it's totally unfair. Now, what the court's going to see is in the coming weeks, these lawyers will all be addressing this issue, and it has a pronounced effect when a district attorney stands up and says that and does that in open court. And I think that is germane what we're talking about and to procedures, Your Honor. So I would just like an opportunity, if the court would allow us, to respond to the people's request for this reopening. As I said, I think that's totally being improper.
Well, Mr. Carpin, what I anticipate doing is after I hear the prosecution's proffer as to what it is they would go into and how it is that they would approach it, then I'll allow you to respond to that to see if it's appropriate.
Thank you, Your Honor, because I think that what we've seen so far, again, is trial in the media. What we saw in court here, to have a witness who's never been before this court, I presume branded as a certified pathological liar, Your Honor, that's outrageous. And if not, would not be done except under the aegis of some kind of qualified immunity here in court. And I think that's unfair to that witness, and obviously it had a great effect upon her. And what kind of message does that send out to other witnesses, Your Honor? Furthermore, all the things that were introduced, Your Honor, the things that were introduced would probably not even be admissible from a standpoint of attacking this lady's credibility. She has some civil lawsuits. How is that relevant as to whether or not on June 12th, 1994, at about 10:45 in the evening, she saw 4 men running from the vicinity of 875 South Bundy? That's going to be really the issue, Your Honor, isn't it?
Absolutely.
That's the issue, and it seems to me that the other things that happen should not be allowed to happen again, because I'm just saying to the court that this is having a pronounced effect, and I know that because I'm being contacted by these people.
All right. Thank you, Mr. Carpin.
Thank you, Your Honor. I should say one other thing. At the bottom of page 1, I think it was clear as we'd indicated to the court. The other witnesses that were turned over, because the court had ordered Mr. Douglas to make that determination, and we should make it clear that he did exactly as you had asked, and make it clear also that this has not been his responsibility prior to January 2nd of 1995.
Well, I think the record speaks for itself.
All right.
Mr. Douglas did indicate that was his responsibility as of the beginning of the year.
Yes, and he took it over. And of that list, of the total list that we've heard so much about, Your Honor, and we dispute Mark Partridge because we think they did know him and had a statement from him, the only 2 people that basically mentioned in the opening statement were Mary Ann Gertjes and Michelle Abdram. And apparently there is no report that we have on the shelf. And the other thing that also comes to mind, Mr. Douglas reminds me, is Colonel recall that in one of his diatribes, Mr. Darden stood up and said, if Ron Fishman tells the truth, he'll say that O.J. Simpson made a statement about getting somebody. Now, Your Honor, we've never seen any report like that. We've never seen any such statement. And so when he makes those kind of statements, or when immediately he knows about Mary Ann Gertjes, in another statement he says, if you recall, if Mr. Cochran had asked me, I would have told him about this witness or these witnesses. How does he know those things, Your Honor, immediately if he didn't know about these witnesses? So I think the court, in being even-handed, which you are, would want to inquire about that.
Well, I've already sanctioned the prosecution severely for their transgressions in the discovery process, and this sanctioned proceeding process, I suspect, will continue throughout the trial.
I certainly hope not after today, Your Honor. It will not be proceeding. I hope it won't be necessary. But I understand that. But I'm saying, how would he then be in a position to give me advice about witnesses if he had known, or to know, have a statement from Ron Fishman, if he didn't know about Ron Fishman? I don't understand that, and I don't think that makes sense. So I would ask the court to inquire about that. To conclude my point, though, of the witnesses that you'd ask Mr. Douglas to proffer before the court, we did that. As Mr. Douglas has indicated, many of these witnesses were out of an abundance of precaution, will probably never be called. But secondly, they have a right to know about it, and we've done that. But almost none of those witnesses were mentioned in the opening statement, with the exception of Gerches and Michelle Abduran, as I said, referring to the list at the bottom of page 1.
Well, you did mention Gerches, Abduran, Partridge, Weitzman, Taft, and Reichart in your opening comments.
Right. I was referring to the list at the bottom of page 1, and I did, in fact, mention the others. And as I said, there are no reports, but I did, in fact, mention them. But I think, again, Your Honor, in the spirit of the law, the prosecution, Your Honor, knows about Howard Weitzman and Skip Taft, because they were down there with Mr. Simpson at the time he gave his statement. Now, we don't have a statement, and it was an oversight, and they should have been put on the list. These are two lawyers. Now, you know, I mean, I don't think the court's going to shoot me over that. I mean, I think that he may want to.
Don't tempt me, Mr.
I don't think you're going to shoot me over that. And Kristen Reichart, Your Honor, they know about. They've interviewed him. They know that's Faye Resnick's boyfriend. And I think that, as I said, with Mark Partridge, they had a statement on him. So I think the court has listened to us. I'd like an opportunity to respond specifically when they're ready. But I'd like to proceed, Your Honor. Let me just close by saying the court can give these proposed sanctions, and you've done that for the prosecution. I mean, I think it should be clear they were sanctioned, and you did that, and now you impose sanction upon us. We will proceed with those. I think that you should make some adjustment in that in the order regarding the delay. I think it's not fair to say it was all the defense. But we're then ready to proceed, Your Honor, and I would like to be able to proceed this morning. Keep in mind, if you want to talk about sanctions, how unfair it is to Mr. O.J. Simpson. But number one, through no fault of his, I couldn't respond immediately when the prosecutors had finished on Tuesday. The court declared a recess. On Wednesday, I was able to start responding. Then we had all these objections from the prosecution. Then Mr. Hodgman gets sick. Then Thursday and Friday, we've been off. The court says, be ready at 9 o'clock. We come in, we get the order about 8:30. We're ready. Ready again. I've been ready for about now 10 days to give this opening statement. Now the prosecutor says, gee, Judge, we need now till 1:30. I mean, at some time, I should be allowed to complete the opening statement, Judge. And I think that that also has taken the form of a sanction. And I think it's a sanction that's not only upon the defense, but directly upon Mr. Simpson. I'd ask the court to allow us to go forward this morning.
All right. Thank you, Mr. Clark.
Thank you, Your Honor.
Ms. Clark. I think what I'm most interested in is hearing what your contemplation is of your proffer regarding a reopening of opening statement.
What do we contemplate?
Yeah.
We have amassed information on several of the witnesses mentioned by Mr. Cochran that allows us to understand precisely why he hid them the way he did. And we are going to prepare those remarks for the court. We've been assembling that information over the weekend, and now that we're finally in possession of the court's ruling, we will address what the court asks us to address, and we're going to have to put that together in a form that will allow me to succinctly state to the court what the points are that we intend to address with each witness. I would simply indicate that the statement taken from Marianne Gerches most recently reflects the fact that counsel alone was in possession of her statement, that she asked counsel to turn her statement over to the prosecution, and counsel for the defense never did. She indicates very specifically that she spoke to Mr. Hostetler, whom we knew to be one of the investigators for the defense, and she told him that she wanted them to turn the statement over to us. So even the witnesses asked to do that, and the defense willfully refused to do so.
Well, Ms. Clark, you're arguing an issue and ruling that the court has already made. I've already made a finding adverse to the defense I've granted a large number of the sanctions that you've requested. I am going to instruct the jury that a transgression of the law of discovery has occurred and has been part of the cause of the delay.
I think that
So
too.
to argue the basis for the court's ruling at this point doesn't help me a lot. What I need to know is, assuming I am willing to allow you to reopen, since this is a highly unusual remedy that you asked for, and the fact that there's only one civil case that deals with that, I've never seen a case allowing reopening after a discovery sanction has been imposed.
When has the court
And
seen
I
an
looked.
abuse, but when has the court seen a
Well-
violation this severe?
You're arguing,
Okay. Well,
I've already ruled in your favor, Ms. Clark.
Okay.
You don't
I'm-
need to tell me how severe it is.
Okay.
You don't need to tell me what the basis is. I think the ruling speaks for itself,
It does. I'm simply.
especially given the nature of the court's finding as to intent and tactical advantage,
Mhm.
which is as harsh a finding that the court can make under these circumstances. So my question to you is, if I grant your motion to reopen, what are you going to say to the jury?
And,
That's the bottom line.
all right, and I've asked leave of the court to.
And what I would anticipate you are going to say is that you're going to tell the ladies and gentlemen of our jury, had the prosecution known of these persons, we would have told you about them X, Y, and Z, and that's what we're going to prove. I think that's about the maximum parameter that I would entertain, and I stress the word entertain.
Okay.
All right, at this point, then, I would suggest that we proceed then with the conclusion of Mr. Cochran's opening remarks, and that after the lunch hour, you'll have the opportunity to come back and ask me to reopen, and I'll rule at that time based upon your proffer after I hear Mr. Cochran's objections. I
Let
would
me-
suggest that, so we can make good use of the court time since we have our jurors seated, ready, willing, able to go.
I would
You
like
want
to
to discuss that with Mr. Darden for a moment?
May I address the court further concerning the expert witnesses?
Certainly.
Mr. Cochran indicated just now that some of the experts have not even examined the evidence. And I find it incredible that any officer of the court could stand before a jury and represent what conclusions and findings have been made when the experts have not even conducted an examination. That assertion that they have not even examined the evidence is incredible to me. If that is the case, and he's made representations as to what their findings are, I think that there's a great deal of credibility lost with respect to those witnesses. Obviously, it's going to be a bootstrapped conclusion. Counsel, who is not an expert, can stand up and tell this jury before an examination of evidence is conducted what the result will be. I find that remarkable. And I think the jury should be informed of that fact.
Well,
I think they
Ms.
should be
Clark-
told, Your Honor.
Ms. Clark, that's an interesting point, but I don't know the full parameters of what it is we're talking about until the disclosures of expert witness lists have been accomplished as I ordered today. I can always re-instruct and re-admonish the jury at any time during the course of these proceedings. You can also bring up during the course of your closing argument that contradiction.
I'm aware of that, Your Honor, but that doesn't address the harm that's already been caused in that counsel has indicated to the jury certain experts exist who will testify to the following, and we had no knowledge and no prior discovery of any, not even their names. Only this morning, because the court indicated it had a suspicion about who that was, did we find out what that was. Now
Well,
he
it's not
tells
a
us.
suspicion, it's just a logical conclusion from what we already all know about the case.
Okay, but that does not comply with any discovery law that I'm
This is
aware
true.
of. All right. So counsel is indicating now that he's going to testify to tire tracks and to shoe prints that were found at Bundy. We have absolutely no report, no knowledge, and no information that any such testimony would be forthcoming. Those should be included in the discovery sanctions as well. With respect to Lenore Walker, I'm particularly surprised and dismayed at what counsel has represented to this court. Counsel represented to this court when last we were here that Lenore Walker was only contacted for the purpose of testifying in this matter in January, just a few days before the discovery hearings occurred. That's false. It was stated in the Los Angeles Times by Dr. Lenore Walker herself that she was retained by counsel in the summer of '94 and that she has spoken to the defendant for hours in preparation for her testimony. So the violation is even more flagrant with respect to her. At least that's according to what she said to the LA Times. So counsel is now continuing to perpetrate a fraud upon this court, is continuing to make misrepresentations concerning the nature of the witnesses that they have contacted and their involvement in the case. He is still withholding more information. There are witnesses whose names we still don't have, and obviously there are no reports. That's a flagrant violation of the law, and now it's compounded by counsel's willful assertions to the contrary of what the witnesses are telling us in terms of when they were retained. How can that be? How can that possibly be swept under the rug? The jury should be told all of this.
Tell me about the LA Times information about Lenore Walker.
That's an article in the LA Times today, I understand. Or yes, was it yesterday or today? I have it upstairs. I believe it's in the Sunday Times, Your Honor. And if the court would like, I can have it brought down.
I'd like to see it.
I will.
But before we, Mr. Cochran, you indicated a desire to address that specific issue. I'd be curious to know.
I think I read the article and what it indicated. First of all, it said, if I recall, Dr. Lenore Walker had known me since the time I was assistant DA and worked in this office, in the DA's office, that she and Geraldine Butt Staley worked on cases that I had the battered woman syndrome as a defense and other murder cases. I think it also indicated that she was contacted, I believe, in December. But she was not retained or brought forward in this case, Your Honor, until after you ruled on the domestic discord. It didn't make any sense. We didn't need her until that point. We don't have a report. The court checks Your Honor's records when we made an application for Lenore Walker to go into the jail to see Mr. Simpson, along with Geraldine Butt Staley, who saw him, is not even concluded, saw him as late as this past Friday. The court will know the time she went to see him. We don't have a report, and she came about. She's only relevant, Your Honor, after you ruled in the domestic discord. I've known her sometime, but she was not relevant in this case until that time. So I think that, I'm more than happy. She was probably talked to. I called her the first time in the fall, but she didn't get involved in the case until after the domestic discord. And I knew her since the 80s.
All right. Ms. Clark, let me ask your staff to bring down the LA Times article, although obviously that source is hearsay.
Let me also indicate that with respect to Mary Ann Gerches, in her statement to us, taken most recently after counsel's opening statement, she indicates that she turned over her day runner, that's a daily calendar.
I know what a day runner is.
Okay. And that has never been turned over to us. In fact, it was never even mentioned that they had it. She indicates that she turned it over to them, and they have never turned it over.
All right. Well, I can see this is going to be an ongoing procedure here. Ms. Clark, however, I think my suggestion that after the defense has had the opportunity to comply with the court's order regarding expert witnesses, we can revisit the matter again, and I can still re-instruct the jury at any time during the course of these proceedings regarding discovery violations.
The problem is that in our proffer to reopen, we would like to include those expert witnesses.
All right. Well, when I hear the proffer, I'll rule on it. But my inclination this morning is to go forward with the jury, have Mr. Cochran complete his opening statements, then I'll hear your proffer, and we'll see where we are. All right?
Can we at least have the defense give us the names of the witnesses they intend to call as to the matters I described, the tire tracks, the shoe prints, the finger cut, the rheumatoid arthritis, those matters?
All right. That seems to me to be a clear intent to call those persons as witnesses, so I think their identity needs to be disclosed, or should have previously been disclosed. Mr. Cochran? I agree that her request is well taken. All right, well, we'll have to take a 20-minute break just to bring the jury down in any event, so you and Mr. Douglas can accomplish that in that 20 minutes. All right. I'm sorry? Certainly.
Before Fishman.
And Mr. Darden, when do you anticipate Ms. Fishman's will be necessary?
February 9th.
All right, are you Cora Fishman? All right, good morning, Ms. Fishman. I'm going to order you to return to this courtroom on Thursday, February the 9th at 9 a.m. without further order, notice, or subpoena. Do you understand the order, ma'am?
Yes.
All right, counsel, your appearance for the record.
Yes. Andrew Rubin, I'm here representing Mr. Schmidt.
Good morning, counsel. Good to see you again.
Good to see you, Your Honor.
All right, thank you, counsel.
Thank you.
One of his clients named a cat after me. All right. Ms. Clark.
Is the court indicated on the recess? I would like to hear the names.
Mr. Cochran indicated he and Mr. Douglas were going to confer, prepare a list for you in the 20 minutes that it takes to bring the jury down. All right. Let's have the jury, Deputy McNair. Thank you. Mr. Douglas, you had something you wanted to say before we start?
I would, Your Honor. Thank you very much. Your Honor, in addition to the comments and to the objections that we lodged with the court in chambers, I would like to add one more point that was just brought to our attention recently. And that is, Your Honor, our review of Section 1054.5b does not specifically authorize a judge to instruct the jury that a discovery violation by defense counsel, for example, may be considered by the jury bearing on the credibility of witnesses. And I think that there is the danger that the language of the proposed instruction by the court gives such a suggestion. Nor does case law, Your Honor, authorize such a jury instruction. Indeed, we submit that it would be completely irrational to make a connection between a lawyer's discovery obligations and the credibility of an independent witness. I think, Your Honor, that there is a danger by such a nexus triggering profound state and federal violations, both due process and of a Sixth Amendment nature, and I would urge the court to strike that connection in the court's ruling. Secondarily, Your Honor, I respect, though I respectfully disagree, with the court's finding that the violation to turn over the witness statements of Ms. Gertjes was intentional. I suggest that before the court can properly make such a ruling, that is, that there was an intentional violation to gain tactical advantage, that the court should most properly consider that aspect within the context of a sworn declaration that I would like to have the opportunity to submit myself to this court, so that the court could then have facts upon which the court might make such a finding if the court is ruling that a violation is being imposed and a sanction is being imposed based on the court's belief that there was an intentional violation rather than an inadvertent accident, as we contend.
All right, Mr. Douglas, I'll give you leave to file whatever affidavit you wish. However, the court's ruling will stand. The court's finding stands. Thank you. Ms. Clark, you're standing for a reason?
No, I submitted the article to the court
Yes.
of Dr. Walker. I've also been informed by several people that she was on. I've been informed by several people that she was on Good Morning America this morning, indicating that she had had some 40 hours of interviews with Mr. Simpson. In light of the fact that Mr. Simpson is in court most of the day, every day, that would preclude her physical capability of having amassed that number of hours unless she had been retained quite a long time ago. And all of this flies in the face of counsel's direct assertions to the court that she had recently been retained. It's now been exposed to be an absolute falsehood. And I think that the article as well in the LA Times makes that clear also, that she was actually contacted through Geraldine Stolley in the summer, which makes it physically possible to have amassed that number of hours. So I think that what the court has before it is further impeachment of defense counsel's most recent assertions even of having been recently retained.
Ms. Clark, I have before me a photocopy of a press release that Ms. Walker released on, Dr. Walker released January the 26th, and the ending paragraph reads as follows, quote, "As we began to examine the evidence over the past 5 months, which included some 40 hours of evaluation of O.J. Simpson himself, we realized that the potential for long-term harm to battered women was present if the facts, patterns, and significance of the battering in this case were misinterpreted, distorted, or otherwise misused by either side." So the fact that they've been examining the evidence for the past 5 months, I think, supports your position that, in fact, there was a relationship prior to just last week. However, having said that, the defense was not in a posture to know whether or not testimony by Dr. Walker would be relevant until the court ruled on the domestic violence issues, at which point the court, having allowed testimony of some incidents and having excluded testimony as to others, then clearly set the issue before the jury. So I accept Mr. Cochran's representation that he did not formally make a determination whether or not to call Dr. Walker until after the court's ruling on domestic violence. But that also causes me to believe that if there's been 5 months of preparation, that there ought to be some notes around.
Exactly, Your Honor. Not only that,
But as I indicated to you, we'll take up the issue of experts after you've had the opportunity to look at the list that was given to you in chambers this morning by counsel.
as I recall Mr. Cochran's representations to the court when last we confronted this issue, my understanding was, and I'm sure the transcript will allay any questions we have about this, will resolve those questions. I believe the representation made was that she had not been contacted until earlier that
Counsel,
week.
we'll go back and look at this again. We've argued it enough, I think. The record's clear what's there. I'll have my staff go back through the transcript and see what's there. But I think my observation as to what occurred here is probably accurate.
The court was not left with the impression by Mr. Cochran that he had just recently contacted her?
No, I'm saying I accept Mr. Cochran's explanation that a formal decision to call her as a witness was not made until after the court ruled on the domestic violence issue. I accept that as being a reasonable explanation here. All right, but the issue whether or not there ought to be some reports back there, I don't know. But it's an issue that we'll address later, as I indicated to you. Thank you.
But while you're addressing that, would you also address the fact that Dr. Walker could not get into the jail without your orders? She never saw Mr. Simpson until you did the orders.
Mr. Cochran, I'm aware of all those things as well.
And the orders were like in December and afterwards, and so you know when she saw him. She saw him during when he was not in court.
Seems to me you're ahead, Mr. Cochran, on this one.
I just wanted, so I want you to look at that. Thank you.
Okay. All right. In chambers, the record should reflect that counsel did suggest to me that I include in my admonition to the jury, my instruction to the jury, some language to the effect that the failure of the defense attorneys to comply with the law of discovery is not evidence of the defendant's guilt and should not be considered as such. I think that is a good suggestion, and I will include that in the instruction to the jury because that is, in fact, the state of the law. All right, Deputy McNair, let's have the jurors, please. I made a decision. Yes, I did. I indicated I would not do that.
The credibility language is going to remain?
Yes. Excuse me, Mr. Cochran, Mr. Douglas, why don't you be seated until I finish re-instructing the jury. All right, counsel, be seated, please. Thank you. All right, good morning, ladies and gentlemen. Everybody seems to be smiling today. Good. All right, ladies and gentlemen of the jury, I need to advise you of certain things. First of all, one of the attorneys has fallen ill, Mr. Hodgman, and he is not with us today. However, the parties have elected to proceed in his absence. Also, I need to instruct you and to explain to you some of the reasons for the delay that we have had over the past 2 days. Ladies and gentlemen of the jury, the laws governing criminal procedure in California require that each side disclose and give to the other side the names of the persons they intend to present as witnesses and any written record or recording of the statements made by these witnesses. The law also requires the disclosure of any real or tangible evidence. These disclosures must be made before trial if the witnesses or evidence are then known. These laws exist to promote the ascertainment of truth in trials, to save court time, and to avoid the necessity for frequent interruptions and postponements. During the course of the opening statements, defense counsel mentioned witnesses who had not previously been disclosed to the prosecution or whose written statements were not given to the prosecution before trial as required by law. This was a violation of the law and one of the causes of the 2-day delay, including the absence of Mr. Hodgman. Keeping in mind that statements by the lawyers are not evidence, you are directed to disregard the comments of defense counsel during his opening statement as they pertain to the following potential witnesses: Mary Ann Gerchis, Michelle Abduram, Mark Partridge, Howard Weitzman, Skip Taft, Christian Reichard. If and when these witnesses are presented to you during this trial, you may consider the effect of this delay in disclosure, if any, upon the credibility of the witnesses involved and give to it the weight to which you feel it is entitled. Please note, however, and this is important, please note that the failure of the defendant's attorneys to comply with the law is not evidence of the defendant's guilt and should not be considered as such by you. All right, ladies and gentlemen, we will now conclude the defense opening statement. Mr. Cochran, do you wish to conclude your remarks?
Yes, I do. Thank you very kindly, Judge.
All right.
DeVito, College of Defense, College of Prosecution. Good morning again, ladies and gentlemen. This morning again, I'll be assisted by Mr. Carl Douglas with regard to some graphics that we have, and by Mr. Howard Harris here also with regard to the graphics. As you recall from our discussion last week, in discussing the evidence, we've talked about the coroner's office and talked about what we expect the evidence to show regarding their shortfallings. We've sought to reply to the things that have been brought up by the two prosecutors in their opening statements. And I believe that at the end of the day, we'd reached the point where I told you we were about to discuss the Los Angeles Police Department and their handling of this matter. I think the evidence will show that the Los Angeles Police Department was the main investigating agency in this particular case. The two main detectives are Detective Philip Van Adder and Detective Tom Lang. They're from the Robbery Homicide Division, and they were assigned this case in the early morning hours of June 13th, 1994. In the course of our discussion today, we will be talking about the evidence which was seized or collected at the scene of Bundy and also at Rockingham. Here we have the first graphic now. Under this scenario, we expect to be talking about the integrity of the evidence. That is, whether or not this evidence is capable of your belief, whether or not it's evidence that is correct and appropriate. How was it collected? And so, for the graphic there, all the evidence picked up at the Nicole Brown Simpson condo at the top, the evidence picked up at the Simpson home on Rockingham, the evidence from the Bronco, any blood, all went first through the LAPD there. And then ultimately from LAPD it was sent out to the various labs, be it the FBI, Cellmark, or the Department of Justice. This graphic seeks to put this in perspective. You can see the LAPD then remains a focal point in their collection of all the evidence that you're going to be required to look at. We expect the evidence will show that this evidence that was collected at these various locations that you've just seen was contaminated, compromised, and ultimately corrupted. In the course of the evidence, we expect to show that. Next. Now, briefly last week, I spoke to you about a detective named Mark Furman. Mr. Furman and his partner, Mr. Phillips, worked West Los Angeles homicide. And they are the two detectives who first were assigned to this case before robbery homicide got involved. Robbery homicide is downtown, I think the evidence will show. These two detectives worked in West Los Angeles where these crimes had occurred. And they were the first ones to arrive at the scene. Although you didn't hear about Mr. Furman in the course of the opening statement of the prosecution, we think he'll be a key witness in this case. Let me tell you why I think he'll be a key witness. I believe the evidence will show that he and his partner, Detective Phillips, arrived at that scene sometime after 2 o'clock in the morning. The evidence will show these bodies were found somewhere around 12:15 on June 13th, 1994. That after arriving at the scene, Mr. Furman did a number of things. You saw him in one of the pictures last week where he was pointing down at allegedly the glove and the cap that was under some shrubbery, if you recall. That was a picture of Mr. Furman at that point. You notice that he had his shoes were not covered, that he'd walked in that location at that point without shoes being covered, that he made a number of discoveries at that particular point, that there was a photographer at some time at that scene at the Bundy location, that this photographer was then summoned along with Phillips, his partner, and Van Adder and Lang to go over to the Rockingham address. We expect the evidence will be that presumably they were going over there to give notice to Mr. Simpson about the death of his ex-wife, and presumably that the children were in police custody at that point. Apparently the parents were not notified of either Mrs. Nicole Brown Simpson or the Goldmans at this point, but they went over to O.J. Simpson's residence. Now, you recall also I told you last week that Detective Furman had previously had contact with the Simpsons. He had responded to the so-called 1985 incident. He didn't write a report at that time, but in 1989 he wrote a written report. In that report he talks about the incident of the 85 incident being indelibly impressed upon his mind. So he had had contact, had been to the Rockingham location. Now the evidence I think will show that he will allege that the reason why he was still leading Detective Van Adder and Lang over to the Rockingham address is because he knew where it was. But I think the evidence will also show from Detective Van Adder that he too had also worked in West Los Angeles and he knew the way over there. But at any rate, I think you'll find that the evidence will show that all four of these detectives, this is prior of course to the coroner ever being notified, leave the Bundy crime scene and they go over to Rockingham. Once at Rockingham, Detective Furman, of course, now by this time the case is now in the hands of the capable individuals from downtown robbery homicide. He continues to play an integral part in this case. I think the evidence will show that he, in looking at the Bronco, now it's still, by all accounts, I think, still dark outside, but he's looking at the Bronco. It's now maybe getting close to 5 o'clock in the morning, maybe the light's about up. He discovers what he believes is a speck of blood on the door. This is Detective Furman. He discovers some more blood allegedly down toward the bottom of the door. That at some point, when these officers can't rouse anybody at the location, Detective Furman is the one who climbs over the wall to go into the premises. That once in the premises, he's the one who interrogates Mr. Cato Kalin. That he's the one who also, after talking to Mr. Kalin, goes back and finds this glove, the alleged right glove, at Rockingham. We have now for you some video relating to Detective Mark Furman, and I'd like for you to listen to what he has to say with regard to the glove. Now, in fairness to Detective Furman, the question he's been asked is about the glove, and they talk about the glove. But in his responses, you'll see, he at some point talks about seeing them at the foot of Mr. Goldman. Mr. Harris, sir?
How far would you say you were from where the bodies were located?
I was directly above the female victim, which was probably 3 feet. The male victim would have been 10 feet, 12 feet.
All right. And from that vantage point, you first observed the glove that you told us about?
Not first, no.
When did you first observe it?
We had flashlights. We were looking at the female victim. We looked at the male victim. I noticed the glove when I walked around to the... After I exited the residence the first time, I walked around to the side, or the north side, north perimeter of the 875 Bundy. There's a iron fence, and through that iron fence you can get very close to the male victim. And looking there, I could see them down at his feet.
You recall, and you heard the testimony that I could see them down at his feet. And the question we'll be seeking to establish in this trial is when he said he saw them down at the feet, was he talking about 2 gloves at that point? Now, also, this detective plays a critical role as he remains at the Rockingham location. You recall last week I mentioned that we expect to call a witness by the name of Rosa Lopez at some place in the case. Rosa Lopez lives next door to Mr. Simpson. She is a lady who's employed by the family there. She is their housekeeper. And there will, we believe, be testimony that Detective Furman had a conversation with Rosa Lopez on the early morning hours after about 7:30, 8 o'clock in the morning on June 13th, 1994. And at that time, Rosa Lopez shared with him her observations that she had been outside the night before and that the Bronco vehicle parked there at the curb at Rockingham was parked there at approximately 8:15, 8:30. It was parked at a kind of a unique angle. And she had reason to remember that as she went outside to walk her dog. She will also testify that she came back outside to walk that same dog at about 10:20 p.m. She saw the Bronco parked in that same location that had not been moved. That the next morning, when Detective Furman had spoken with her, the Bronco was still parked at that same angle, as though it has not been moved all night. She will share with you what, if anything, she said to the detective that morning. You will find out whether or not he reduced any of this conversation to a report, whether or not that report was ever forwarded to anybody, whether he told any of the detectives about it. We expect that she also indicated to Detective Furman that Mr. Simpson left this residence somewhere around 9 o'clock, and there will be testimony that he and Mr. Cato Kalin went to get the McDonald's hamburger. She was aware and heard his voice when he left, that she heard what she believed to be prowlers during this period of time and became quite frightened. We expect she'll also testify that she heard Mr. Simpson's voice at around 11 o'clock or a little after that. And when she heard his voice at 11 o'clock, it appeared as though he was leaving. And she did not hear his voice anymore that particular night. That after Mr. Simpson's voice was no longer heard, after he presumably had left the Rockingham residence, that she heard men's voices beginning at about 12 o'clock, lasting until about 3 o'clock in the morning. She was not able really to fall asleep until perhaps 4 o'clock that morning, and was awakened because I think the gardener came that morning, and she also had this conversation with Detective Furman, who came and showed his badge and then came inside of her house. So we think that, in truth and fact, Detective Mark Furman will play a very, very critical role in this case regarding his testimony. Now, let's go back, if we're going to talk about the LAPD, and let's look at the statements regarding the coroner. You'll recall last week I indicated to you that The coroner's office, for some reason, wasn't called initially. They arrived at the scene almost 10 hours after these bodies had been discovered. Let's look for a moment, using the Elmo with Mr. Harris at the sequence of what took place, and then for the record, I'll read certain things into the record from the transcript, Your Honor. As clear as can be. The underlined portions I will read for the record. This purports to be, and we will establish at the time of trial, this is a conversation that took place on June 13th, 1994, at about 6:49 in the morning, just before 7 o'clock. And it's a telephonic communication between the deputy coroner, Paul Willis, and Detective Phillips of the LAPD, Phillips being Furman's partner. Detective Phillips, I got a double homicide that we want to let you know about. It's going to be, the press is going to be crawling on us like ants when they find out what's going on. Detective Phillips, this is the first call, and we got a lot of work to do yet. But we need to get you guys rolling out here so we can get these bodies, which are visible from the street, out here as soon as possible. If I can digress for just a moment, you recall that he's saying this is the first call from Phillips to the coroner's office at 6:49 for bodies that were discovered by the police at 12:15 a.m. He also says something else that I think the evidence will show is very interesting. When he says that we're going to get you rolling out here for these bodies which are visible from the street. You'll recall that when I spoke to you last week about Ellen Aronson and Dan Mandel walking past this location at 10:25, not hearing anything, not seeing anything on the sidewalk directly in front of 875. And you have seen the other photographs of what you could see from that sidewalk, and it's clear from his statement you could see these bodies, and of course there was all the blood with the scene. Continuing on, we kind of not following procedure, but we are kind of asking a favor, and you know, kind of work a little bit on this one. So we have the detective saying at this point they're not following their own procedures, and they're asking the coroner's office to do them a favor and cooperate with them. Thank you, sir. We'll go to the next page, page 240 for the record. This is Detective Phillips again, still talking to the deputy coroner, Mr. Willis. Detective Phillips. Well, you can see them, yeah, from the street here. They're a little off the sidewalk here in front of the house. But the problem is, when this thing breaks, we're going to have news from everywhere here. It's going to be a high-profile type deal. It's the ex-wife of a very prominent sports cast star or sports celebrity. Then he's asked a little bit above, he says, okay, I'm going to have to trust you on this. It's O.J. Simpson's ex-wife. That's Phillips telling the coroner again. And he goes on to say, the coroner says, oh boy, okay, and Phillips says, and he's in Chicago, and Willis says, he does not know anything about this, and Phillips says, he knows now, and that's what's going to break this thing wide open. Next page, page 241, Mr. Harris, sir. Now, Mr. Willis hears this, and I think the evidence will show he's the coroner. He wants to get rolling. And on this page, in page 241, here's what Willis says. Okay, you want us rolling out now. And then Detective Phillips says, hold on a second. Tom, and I think the evidence will show when he says Tom, he's talking about Detective Tom Lang. So you're not confused, there's two Tom Langs in this case. It's the Tom Lang who sees Mr. Nicole Brown Simpson out on the sidewalk, and he sees the Mexican gentleman behind her at 10 o'clock, and there's Detective Tom Lang, who is Detective Van Adder's partner. So he says, hold on a second, Tom, you want the coroner now? No, hold on a second. How long? Okay, you're just getting the first call. And then Phillips goes on to say, we'll give you a call back when we want them moved, presumably meeting the bodies, I suppose. Detective Phillips, it's probably going to be about an hour to an hour and a half. So here we have them calling more than 6 hours the very first time, at 6:49. Then when the coroner wants to roll, or says he wants to roll now, they then say maybe an hour to an hour and a half later. Move to the next page, please. All right. Phillips says, what I'm going to do is I'm going to give this to the supervisor because I'm leaving now. Phillips says, all right. Willis says, and tell them that you're going to be calling back about an hour and a half. Phillips says, okay, and again, we don't want that out. That essentially ends the first conversation. To put it in context, let's see if and when they call back. And we will present evidence to show that at about 8:08 in the morning, on June 13th, 1994, there was, in fact, a second conversation between Detective Phillips and a Mr. Richard Heath, then of the coroner's office. Detective Phillips says, we already gave you guys the first call several hours ago on Bundy. Heath, yeah. Phillips, okay, can you give me an ETA, an estimated time of arrival, if you started rolling now? Some conversation with Phillips, with Heath rather, and Heath goes on to say, yeah, my name's Heath, H-E-A-T-H, and I could give you approximate arrival time of driving time from the main office in about maybe another 15 or 20 minutes added to that. And Phillips says, okay, so you're talking a good 45 minutes then? Detective Phillips, to an hour. Next page, sir. Detective Phillips says, you're not going to roll them for an hour? And Mr. Heath responds, no, we'll be there within 45 minutes to an hour. Now, we think that this evidence is a very important evidence because it starts right at the beginning of this investigation by the Los Angeles Police Department. First, they've already failed to notify. Then when they do notify, they've got so much work to do yet. We know that the coroner's office doesn't come out there until they don't get the final call till 8:08. And so we know then perhaps, according to this man, Mr. Heath, it's at least 1 hour or so after that before they even get out to the scene. You've heard me mention Detective Van Adder, who is the detective in charge of this scene, a very experienced detective from robbery homicide. And as with all of the witnesses in this case, their credibility will be questioned, and we'll be looking very closely at their credibility and what they did that night and how they conducted themselves. We must do that also with Detective Van Adder. Detective Van Adder, on this particular morning at about 10:45, sought a search warrant. As the evidence will show, Mr. Simpson was not in Los Angeles, he's in Chicago. The detectives had gone over the wall first, but thereafter they sought a search warrant. That's not relevant, but what is relevant is the credibility of the detective and what he said to the judge in seeking to get this search warrant. Mr. Harris? And what is the number? We should be giving numbers.
That is D40.
All right. You'll see in this number.
D41.
This is D41. It's a search warrant and affidavit, and you'll see it signed by Philip L. Van Adder on June 13th, 1994 at 10:45 in the morning now. And this is after they've gone over the wall, etc., and this is an application to a judge to try and go into the house and search. A sworn affidavit. All right?
42.
All right. And this one, Mr. Harris?
43A.
All right, you pull that up.
And D43B.
Now, here's what the detective in a sworn affidavit says to the judge to get this warrant. It was determined Simpson had left on an unexpected flight to Chicago during the early morning hours of June 13th, 1994. Now, we will introduce evidence to show that that was a direct misrepresentation and untruth, that the police knew from Cato Kalin, the conversation with Arnell Simpson, that Mr. Simpson had been on a long planned trip to Chicago.
D44.
And
D45.
he indicates that himself, that by interviews of Simpson's daughter, that would be Arnell, and a friend, Brian Kalin, he writes that in. That's what's in the writing to the judge to verify the fact that O.J. Simpson is like gone on this unexpected trip. like run away to Chicago. And he uses that as a reason in talking to the judge.
46A.
Next thing I'd like to show you is that is the statement from Brian Gerard Cato Kalin. What's that number, sir? Now, thank you. This statement from Brian Gerard Kalin, you notice this statement was taken by the police June 13th, 1994 at 6 o'clock in the morning. Remember I told you that Detective Furman went into his room and talked to this man in the early morning hours. And Simpson, the statement is, Simpson told him he was going to Chicago for Hertz Corporation. So they knew why he was going to Chicago. They knew it was not an unexpected trip. So this was a lie when they were talking to the judge at that point.
249. 250.
The next issue of credibility deals with the detectives indicated to the judge who they were seeking the search warrant. They observed what appeared to be human blood, later confirmed by scientific investigation personnel, be human blood on the driver's handle of the vehicle. Well, the evidence will show that they may have confirmed it at some point much, much later, if ever, but they had not confirmed it at 10:45. It was not human blood. They could not confirm human blood. So that was another misstatement to the judge at that particular point. Now, in addition to that, and I'll read these for you, the other inaccuracies of some importance that we think the evidence will show are as follows. The detectives in seeking this particular warrant never disclosed to the judge the manner in which entry was made. That is, they'd already climbed over the wall. They never bothered telling the judge that. And then finally, the final inaccuracy that I think you will find of some great relevance, the fact that Mr. Simpson had in fact been contacted by Detective Phillips and had volunteered to come home, taking away from the warrant any implication that he had somehow fled the scene. That was never done. Now again, this is the evidence from their files and based upon what their lead investigator said to a judge. And at some point in our opening statement today, I want to characterize for you how Mr. Simpson conducted himself in the early morning hours of June 13th with the way that the detectives conducted themselves. This brings us then to a discussion of the Bundy crime scene. You recall briefly the other day I talked to you about, we think the evidence will show ultimately this was a place of the gathering of the evidence. And that we think the evidence will show that it is very important at the crime scene to secure this area. That people should not be walking through the evidence, should not be tracking up the evidence, should not be touching things without gloves, should be in some way protected, because this evidence is all very, very sensitive. We would expect that hopefully by the time of trial, you will actually have some footage from local televisions of how the detectives and how many people were out there, and whether or not they were, in fact, wearing anything over their shoes. You've already seen in the prosecution's opening statement Detective Furman's shoes and how they existed at the time. We think the evidence will show that this scene was tracked and traipsed up, and the gathering of evidence was a complete disaster. And we feel that the evidence will be shown to be contaminated, compromised, and corrupted, as we've indicated earlier. Now, Your Honor, before we show this next graphic, I want to say a word to counsel, and you may want to use your switch.
I've already. I want to direct photographers not to attempt to take photography of the screen in the courtroom.
I've spoken so the family of Mr. Goldman will be aware with regard to this picture. This is the only picture that in any way could cause any concern, Your Honor, but we'd like to move on at this point. Now, this purports to be a photograph of Mr. Goldman's body while still at the scene of the Bundy location. And you will notice several things about this particular photograph. I believe the evidence will show, first of all, that the lady whose shoes are there, these shoes are uncovered. She's standing on some kind of a white sheet or something of that nature. You can see blood on this photograph. She has nothing over her shoes. She's standing there. You see the body. And you'll see something else interesting. You'll see some gloves. Now, these gloves have blood on them. And these gloves have now been dropped on Mr. Goldman's body. Now, these gloves are, the evidence will show, are typical of the kind of gloves that are used at the scene to pick up evidence or to collect various and sundry things. And yet you see these gloves now found on Mr. Goldman's body in this fashion. And we think this is typical of the way things were conducted at that particular location at that time.
Thank you.
Thank you, Mr. Chairman. We expect, as we indicated last week, to show that based at this particular crime scene at Bundy, there'll be a number of things that we expect the evidence to show. That one of which is this crime scene and the patterns of the crime scene are consistent with a major struggle. Mr. Ron Goldman's blood, as I told you, should be all over the perpetrator, especially in the upper and middle parts of the perpetrator's body. You will recall that Detective Furman's description this morning, where he described this rather small area where Mr. Goldman's body was found. You recall he talked about a fence, and you've seen, I think, some pictures. You'll see a tree in the area. It's a very small area. In fact, he had to go outside to look outside the fence to see where the body was. A very small area. And I think that you'll find if there was this major confrontation, and you recall last week Mr. Goldman's hand, that I indicated to you, I expect there'll be testimony that that hand came in blunt force trauma with one of his perpetrators or one of the perpetrators there. And there would be some marks and some injuries, it would seem. Plus there are trees, there's this fence, and there was a violent struggle. So that if you recall the pictures of Mr. O.J. Simpson last week, you understand that will be important evidence as to the lack of any marks, bruises, or anything of that nature. In the area, we expected the scene to also show that in the area where these murders took place, there are a number of footprints in a very small area, which means that most likely the perpetrator had to be there for a period of time and that there was this pattern of fighting. I think the evidence will be in this case that Mr. Goldman's blood is on different areas of the location, which means that he too was moving around. So there was this kind of a confrontation or this fight that went on over a period of time as one is fighting for one's life. And as you know, it was a violent struggle in which he ultimately was stabbed some 31 times. Now, the prosecutor, 30 times. The prosecutor indicated to you all this happened very fast. And I think that you'll see from the evidence that that's not exactly correct, given the situation when one is fighting valiantly for their life. There was some testimony last week about certain blood drops, I think, by the prosecutors that were at or near the many footprints. And I think that you will find that it'll be very unusual and that it'll be a remarkable occurrence that there are only 4 drops of blood that they talk about and so many footprints. Further, we'll look very closely during the course of this trial at the glove, at both gloves. We'll look at the glove found at Rockingham, the right glove. We'll look at the glove found at Bundy. And we'll be looking to see whether or not there are any cuts on those gloves consistent with any cuts or anything on Mr. O.J. Simpson's hands. We expect that there, as I mentioned to you last week, there will be fingerprints on the railings that are fresh at Bundy. And we think that the evidence will show those fingerprints are not O.J. Simpson's fingerprints. That there are hairs on the cap and the glove at Bundy that are not O.J. Simpson. Thank you, Mr. Harris and Mr. Douglas. Now, you'll see in the exhibit up on the board, the large board, the video exhibit, you see a lady against the Bronco. That's the Bronco that you hear a lot about, and that's a photograph taken on June 13th, 1994. You'll see the tow truck behind the Bronco. You see this lady up, apparently peering in the window of the Bronco. And we expect to show that this Bronco, which you heard that there's important evidence therein, was not secure, that people such as this lady graphically were allowed to walk up, touch it, and when that Bronco left that location, there'll be evidence that there were at least 2 coffee stains on the hood of the particular Bronco, that it wasn't secured, that it wasn't preserved, that it wasn't made so that you could count on that evidence.
That is D63.
All right.
D64.
All right. Now thank you, Mr. Harris. The Bronco was, of course, impounded. All right, Mr. Harris.
D68A. D68B.
All right, and there were some special instructions to take the vehicle to Print Shack, PAB, across the street of Parker Center. And then they note for us that there are 2 coffee stains on the hood, disregard not related. You will have to make the determination of whether that should be disregarded, however, because if this vehicle was properly handled, it's a question of whether or not those coffee stains would even be there. Mr. Harris?
D69. D70.
All right.
D71.
After the Bronco had been to the print shed, it was then removed and taken to the impound at a place called Viertels, V-I-E-R-T-E-L-S, the towing yard here in Los Angeles. And you'll see it's impound, and you'll see the 94 Ford Bronco again, and again the license number. Mr. Harris?
D72 and D73.
Let's see. When they got this Bronco at Viertels, let's see if they used this same form. The robbery homicide, RHD there you see. And you see that the check where the prints or evidence or give special care is no longer checked. There's nothing there. Nothing in that location.
D74 and D75.
This will tell you what instructions were given regarding that Bronco as early as June 14th, 1994. I think the evidence will show. The instructions were hold until released to rep from Hertz Corporation. I think there'll be evidence this vehicle was actually owned by the Hertz Corporation. You'll notice that no special precautions were taken. This vehicle was being held for release to the representative from the Hertz Corporation at that point. Of course, then now we're back to this question then of the integrity of the evidence, and you have the Bronco there going through LAPD, than anything out of the Bronco. Now I'd like to walk over, with the court's permission, to move closer without blocking anyone, with the so-called Bronco timeline. Excuse me, please. May I proceed, Your Honor? Thank you very kindly. This is the so-called Bronco timeline, and let's see if we can put this in perspective for you. There'll be testimony that the LAPD announces that the Rockingham site was quote-unquote secured. And there'll be a major question regarding that. That's in June. We know that there was the initial search of the Bronco for blood and trace evidence on June 14th. Then, within a day thereafter, on June 15th, 1994, the vehicle was towed to Viertels. And that's the towing yard I just spoke to you about. And that's the place where there was the only indication was hold for release to the Hertz Corporation. And so you can see in June what took place. Now, we know and we expect there will be testimony that as early as June 15th, the day that vehicle, the Bronco, was towed to Viertels, there were documents taken out of the driver's side pouch. We expect there will be testimony from a man by the name of John Meraz, M-E-R-A-Z. Mr. Meraz will indicate that they all knew down there this was O.J. Simpson's vehicle, that he got inside that vehicle. And getting inside, he took some receipts or invoices. And I think the evidence will be that some of these receipts or invoices were made out or in the name of Nicole Brown Simpson. So I think you'll find in the course of the evidence, Nicole Brown Simpson also drove that vehicle. There'll be further evidence that she was in the vehicle, perhaps had gone to the cleaners or some place to pick up some item. But Mr. Mraz will tell you that he took these items out of the driver's side pouch on or about June 15th, 1994. He will say that he put those items back in to the Bronco, but the items were then subsequently stolen or taken in another burglary of this particular car that's supposedly secure on Vertel's property. The upshot of it is that today, 7 months plus later, we don't have any of those receipts. They've been stolen, they've been taken, they're gone from this supposed secure vehicle in custody of the police or in Vertel's. And so this Bronco timeline seeks to spell that out for you. You'll note in going back that we have a smaller picture of the woman touching the Bronco. That's still while it's at the scene. You know what's happened on the 14th, then the 15th, and we move on. Mr. Mraz takes the documents initially on the 15th, and I think he says he puts them back almost immediately, within a short period of time. They're kind of like souvenirs, I suppose, if you believe what he tells you. But Vertel's does not report the removal of the documents to the police and the police commission until July 11th, 1994. Almost a month later, the official word came out that these documents have been taken and they're missing. And of course, they then start an investigation to try to find out where these documents are. This Brown timeline talks about this whole period of time when we think the evidence will show the Bronco was improperly stored without the appropriate holds, and then when it was improperly stored, that some bad and unfortunate things happened with evidence having been lost. Now, you'll see, between this period of June 15th, that's the date that the Rats got inside when it was brought to Vertel's, and August 26th, did not observe special care rule to preserve the integrity of biological and trace evidence. We think there will be testimony that this vehicle, it's possible for this vehicle for any number of people to get in and out of that vehicle, and there was not the hole on it that it had in the print shack. Then, lo and behold, on August 26th, between the period of August 26, 1994, and September 1st, 1994, there was, done by the prosecution, an extensive search of the Bronco for biological and trace evidence. They went back looking for evidence used in this trial. Now you can see this is for a vehicle that had been towed there on June 15th. So what is that? 2 months plus, almost 2.5 months. They go back. Now they're looking for extensive search for biological and trace evidence. This is a vehicle that we know has been basically improperly stored. There's been at least one burglary or trespass, and maybe 2 if Mr. Mraz is believed. Yet then they then go back and seek to get evidence out of there. And this goes into what I've tried to describe for you, of the graphic there, of the integrity of the evidence, what happens to that evidence, where it goes before it gets to you, and who has had an opportunity to contaminate it or compromise it or in any way corrupt it. That leads us to the point of this integrity of evidence being contaminated, compromised, and corrupted. And we think that the saga of the Bronco illustrates this concept of the evidence being contaminated, compromised, and corrupted. Thank you. Well, now, with your permission, turn our attention now to this whole concept of a discussion of DNA evidence in the Los Angeles Police Department. I suppose that there's a saying that if you have garbage in, you get garbage out. And we have several charts that we think will be illustrative of this whole concept of DNA evidence and what it actually means. Mr. Douglas is placing a chart on the board. And Mr. Harris, do you have a laser? The black box. You did the black box already. And we put the black box up because, again, this deals also with the integrity of the evidence. Now, with regard to this particular exhibit, before I get to that, Ms. Clark, I want to make a few statements, and I'll let you know when we get to that. All right. Nowhere, I think, will you find in this case is the problem of the evidence being contaminated, compromised, and corrupted more important than the area of DNA testing. This is the evidence will show is a very new and powerful technology. In the past 5 years, police departments and crime labs have tried to transfer this DNA test that has been used for research and medical diagnosis and apply it to crime scene samples. We expect, though, you will hear in the course of the evidence, this transfer of technology has not been simple or easy. And so I want to share with you, in the course of my opening statement now, some differences between DNA testing for medical purposes and forensic DNA testing on crime scene samples. Remembering in the graphic, that all evidence passes through first the LAPD's hands. If it's compromised when it starts, it's compromised when it comes out. If the evidence was contaminated at the scene or mishandled by the Los Angeles Police Department, it doesn't matter what DNA tests are done afterwards, how many times they're done, or which laboratories did them. The results will not be reliable, we expect the evidence to show. Now, to understand the problem of contamination, one must understand, first of all, how small these samples are. And Mr. Douglas has gotten ahead of me just a little bit. Go back to the small amounts of DNA. And for illustrative purposes, to illustrate this for you, this is a chart that's titled Small Amounts of DNA from Specks of Blood. Now, what we have is a regular-sized penny here at the far left. And I want you to be able to compromise, or despite that, I want you to be able to compare the regular-sized penny with 20 nanograms of DNA. And that amounts to, those of you who see very well, I'm pointing to it, almost like a pinprick. It's 20 nanograms. Much of the evidence in this case, you'll be asked to make decisions regarding, is 1/10 of that amount. 1/10 of the 20 nanograms are 2 nanograms, an amount so small that you can't even see it. That's what we're trying to demonstrate in this chart again. The penny, the 20 nanograms, the 2 nanograms, an amount that you could not even see with the naked eye. So Douglas, and that exhibit I was just referring to, Your Honor, was
207, Your Honor.
now, Mr. Douglas.
This is exhibit 210, Your Honor.
Oh. We think the evidence will show, in concluding the last chart that was just taken down, that these small, minuscule amounts of DNA are very easy to spread around. They can get on your clothes, in your hair, tweezers, scissors, other tools, be moved from one place to the other without anyone seeing or knowing what is happening. And this, of course, is how you get contamination. Now, during the course of my remarks today and then last week, and before that, the remarks of the prosecutors, we've all stood at this particular podium. If I sneezed, or if any saliva came out, or if I scratched my hair and any dandruff was there, or if I touched this and had any blood on my finger or a splinter there, if Miss Clark did likewise, if Mr. Darden did likewise, then our DNA would be on this area. And if I took a handkerchief out and wiped this, such as they do in labs, that would pick up the various DNA that's here. You can't see it. That's how small it is under these circumstances. So that gives you an idea. If we were to wipe it across here, a handkerchief, it could now be taken to the lab and allegedly tested. In fact, some medical labs, as I said, do in fact do this, and it's done in the lab in a scene to determine whether or not there's any contamination. That's how they test it, to see if there's contamination. If you're trying to test to see if someone is going to be able to be compatible for a particular organ transplant, they check to see, because you can't see this. Now, as I gave the example, if I had been the only one here, you might expect to find only my DNA. But if Mr. Darden and Ms. Clark were here, you might expect to find their DNA. If Mr. Van Adder here sneezed, you might find his DNA. So there's all kinds of ways in which we have this possible contamination. And one of the problems with the test is that it cannot tell one person's DNA from another. This is what we call, and I think the evidence will be, a mixed sample. There's a great controversy, we think the evidence will show, about whether small mixed samples can be tested reliably, even if everything else is done properly and there is no contamination. So if you add contamination to it, then you can see what the problems are. Now, to give you a perspective, now, ready. This board that I'm now going to refer to is the so-called DNA testing technology transfer board. What we want to demonstrate here, as you recall, I said that over the course of the last 5 years, what we're trying to do here is to transfer from what we use in medical research and to exclude suspects primarily to the field, to forensics, to crime scenes, to try and make it work in that setting. This is, as I indicated to you last week, cyberspace or 21st century technology. And I think you will find the evidence will be that the collection procedures are 19th century or covered wagon collection procedures. And that's why it's such a problem. And so if you looked at this medical research area, generally you could expect that in the medical field that there are clean samples, more than likely in a clean medical lab. The blood is carefully taken under antiseptic conditions in hospitals. And in a forensic setting, DNA testing is done by definition generally. Dirty samples are taken from crime scenes, from sidewalk, from carpets. And they're exposed to all sort of contamination. That there are many different sources. These are, as you know already, these are minute specks of blood. There may be saliva, there may be skin, cells, dandruff, as I indicated to you. Even a spray of a sneeze can contaminate the forensic sample. So what I want to do in this example, we have these charts here, is this. In comparing the medical research, we're going to compare the medical research with the forensic and see which one is more likely to be reliable under the circumstances. Well, I think that the evidence will show that as opposed to the clean samples and the dirty samples, in this instance, the clean sample in the medical lab will be far more reliable, something you rely upon. The next area we'll be talking about is generally in a medical lab, you have a general sample size. The doctor can have whatever sample size he usually wants or needs. In forensics, the samples come generally in very, very limited, minute amounts. When working with such small amounts, often the test can only be done once. And of course, we think the evidence will show that it's harder to produce reliable results under those circumstances. In fact, you will hear, we think in this case, that most of the important DNA tests performed by the prosecution were done with amounts of DNA that were actually below the preferred amounts for reliable testing. So if you talk about the medical research labs having a general sample size, and in the forensics area having minuscule sample size, again, you can see there is a higher risk of contamination in the minuscule sample size. And that brings us down to the unmixed samples from known sources. As you know, and Ms. Clark alluded to this in her statement, in a medical setting, you have people that you know. If you have a lady who's going to have amniocentesis, you know who that is. You have someone who's going to give, one person's going to give somebody else a kidney, you know who they are. So you have known sources that you're dealing with. And that makes a big difference, as I think you'll see during the course of the testimony. In medical testing, we take these unmixed samples from known persons. In forensics, we use and collect samples that could be mixtures in varying amounts from a number of unknown people, because you don't know who's been out there, who's walked, who's sneezed, who's bled, who's scratched their head. You don't know over a period of time. We expect that you'll hear, again in this area, that the new forms of DNA testing used by the prosecution in this case are just not reliable enough to use when analyzing mixtures from unknown sources. And the key thing here being mixed samples from unknown sources. So again, once again on forensics, a higher risk of contamination. Then in the lab, in the medical research area, there is generally minimal handling. This is fairly clear and straightforward. There's less handling than in the scene when you have someone going out trying to collect something. Contrary, as I said, to what the prosecutor told you last week, the evidence will be it's not as simple it's wiping up a spill in your kitchen. This technology is so sensitive. It's not that simple at all. You and I just shouldn't go out and do this. We can do it. We wanted to use the same techniques they're using with the LAPD, but you get results that are all unreliable. So between minimal handling and multiple handling, you can see again, there's a higher risk of contamination with the multiple handling. Error rates, better known. And that's because, I think you'll hear testimony, that in the medical labs, they subject their results and things to tests. I mentioned the wipe test. In labs, they do that because they're concerned about contamination in the labs when you go to the doctor. You want to have the doctor make sure his lab is contamination-free as near as possible. It brings about confidence, and that's what we've done a whole industry based upon. Transferring this technology to the forensics area, the error rates are not nearly as well known, as I think you can see. So again, there's a higher risk of contamination and error in this area also. I think you'll find that in the course of the testimony that the labs have a higher standard for doing DNA testing in medical laboratories. They're much stricter on themselves than the standards that forensics and the police departments and laboratories are using. And so you can see how important it is. In one case, when you're talking about these high standards, you're concerned about whether or not your organs will be compatible, if you want to have an organ transfer or whatever. And the other, concerned about somebody's freedom, their virtual life. And so we're going to see whether or not, under this scenario, whether or not there aren't higher clinical lab standards when you're concerned about somebody at the hospital than you are when somebody's on trial for their very life. Given that, lower lab standards and the lack of testing, again in this area, in forensics, there's a higher risk of contamination and error. I mentioned this earlier, but in the labs there is this rigorous proficiency testing. And of course, I think you'll find the testimony will be that in forensics, very rarely do they do any blind testing, no outside agencies. They give themselves easy tests and almost never take blind external proficiency tests. And that has a real bearing on the overall proficiency here. And so, again, I think you'll find there's a higher risk of contamination and error in the forensics area, again. And finally, with regard to statistical controversy in this area. In medical testing, usually you're just trying to see if someone has inherited a copy of a diseased gene from their parent or whatever, has the correct genetic types for transplantation of an organ, or has been infected with a harmful bacteria or virus. That's what you're looking for. And there's no elaborate statistical estimates are needed to get reliable test results for that. In forensics, we think you'll hear testimony that there's a bitter and complicated statistical controversy regarding this entire area, DNA, and specifically PCR, about a DNA match and what a match means. And while we're about it, I think the evidence will show when you hear the prosecutor talking about it's a match, it's a match, it's a match. What she really means to say is that it's consistent with. These are not fingerprints, consistent with someone else's genotype or with their blood type. So with regard to this whole area of statistical controversy, again, the forensics area, the higher risk of contamination error in this area. So if you look at this chart, you look at blood on both sides of that, you can see clearly, and I expect the evidence to be, that because of the dirty samples, the minuscule sample size, the mixed samples from unknown sources, the multiple handling, the error rates not well known, the low lab standards, the easy proficiency testing, and the major statistical controversy. In all those areas, the seeking to transfer this technology to forensics is fraught with all kinds of problems, and there is a much higher risk of contamination and error. Now, we expect that during this hearing you will hear some astronomical numbers presented regarding the DNA test results. And these numbers are part of what I was telling you, the statistical controversy, whether or not these are accepted in the science. And these numbers also only address gene frequencies. These are not fingerprints. And the numbers that you will hear, if you hear them in this case, have nothing to do with the issue of contamination that we've been talking about. They do not have anything to do with the issue of laboratory errors. They don't have anything to do with the issue of tampering, whether the sample was tampered with. And they have nothing to do with other important DNA issues which you'll hear about in the course of this case. Specifically under the DNA testing aspect, we think that you'll hear testimony in this case about polymerase chain reaction, the so-called PCR testing. And I think you'll find out in here that the very best medical and research labs that do PCR have contamination problems. And as I mentioned to you last week, I think that you'll hear that this is an area that presents a real problem. We expect during the course of our evidence in this case to show that from their own studies, the LAPD's laboratory is a cesspool of contamination. Looking at their own records and the tests they've run, we will demonstrate for you what those records show. We expect then in this entire area, the evidence will show that the careless, slipshod, negligent collection, handling, and processing of samples by basically poorly trained personnel from LAPD has contaminated, compromised, and corrupted the DNA evidence in this case. And, Your Honor, that might be a good spot. Should we go further?
All right. Thank you, counsel. All right, ladies and gentlemen, we're going to take our recess for the noon hour. Please remember my admonition to you. Do not discuss this case amongst yourselves, form any opinions about the case. Don't allow anybody to talk to you about the case, and you are not to perform any deliberations on the case until the matter has been submitted to you after the completion of the case. And we will resume again at 1:30. All right, we'll stand in recess. Thank you, counsel.
She's on her way down. Have to get an elevator or something.
A young trial lawyer in Pasadena, I recall trying a case in Judge Ladig's courtroom, being late in a jury trial, and Judge Ladig had the jury out sitting in the box as I walked in late from lunch. And he never said anything to me, but I got the message.
It's happened to me, Your Honor. I apologize, we had a late meeting, which delayed lunch considerably, and I didn't expect it to take as long as it did.
Well, keep that experience in mind. All right, counsel, let me bring up one matter before we invite the jurors to rejoin us for the continuation of Mr. Cochran's opening statements. Counsel, when you use a videotape or an audio tape during the course of the opening statements, or any time during the course of the trial, and there's a transcript that's available, I forgot to ask you for the normal stipulation that the court reporter need not attempt to take down what is on the video or audio tape at that time. And Mr. Cochran, you did use that videotape during the course of your opening statement. Is that stipulation agreeable to you?
Yes, I will be so stipulated that
Yes, I'm so stipulated.
All right.
not to take that.
Thank you, counsel. All right, Deputy Magnaron, let's have the jury, please. right, counsel, please be seated. All right, good afternoon, ladies and gentlemen. All right, Mr. Cochran, do you wish to continue your opening remarks?
Thank you, Your Honor. Thank you very kindly. Vito and counsel, gang. Good afternoon, ladies and gentlemen. I can make a promise to you this time that I will finish this opening statement this afternoon, barring any unforeseen calamities. We'll be finished this afternoon with the opening statement. Thank you for your patience, and ask you again to keep an open mind. Just before we concluded lunch, we were talking about the importance of DNA, and we still have some more DNA to talk about. I have two charts now I want to discuss with you briefly. They're labeled, for the record, PCR amplification charts, and we're seeking to explain how this concept works, the polymerase chain reaction, or PCR, this technology I've been talking to you about as a facet of DNA, of technology. PCR tests take these very, very small samples that we've been talking about, and now you've seen some of which you cannot even see, and they are amplified up, kind of a molecular Xeroxing, if you will. And that's what we're trying to demonstrate here. We expect the evidence to show and that scientists are not yet able to actually examine the small amounts of DNA contained in minute specks of blood. They must first amplify the DNA so there's enough of it to examine. Amplification, or amplifying DNA, as I said, is like molecular Xeroxing. You start with a small amount of DNA, and they go through these various cycles. Each cycle doubles the amount of DNA, and they do this 32 times, the evidence will be, before they have enough DNA to examine. Now, this first chart shows what happens when you have a single piece of DNA that is then amplified or doubled 32 times. And then it goes from this one fragment that you may not have been able to even see to over 4 billion fragments, as is indicated on the particular chart. Now, that is the molecular Xeroxing, made as, hopefully, as clear as we can make it, in line with what we expect the testimony to be. Mr. Douglas, we moved. What's the number of that chart, Mr. Douglas? Now, referring and directing your attention to number 209, which is the amplification of 4 fragments. Now, this chart seeks to illustrate for you what happens when there may be a mixture of DNA in the sample. Heard us talking about mixtures, and heard me this morning talk about the wipe test with a handkerchief on this particular podium. This chart shows 4 different fragments of DNA at the start. And after this mixture, just like we did in the previous chart, is amplified up, there will now be over, the bottom should be 16 billion or 17 billion fragments. Extra fragments of DNA, the evidence will show, could get into the sample in any number of ways. And that's one of the vices of this particular system and its reliability. From someone coughing on the evidence, from flecks of blood which may come from one sample and be passed on to another sample, from specks of blood that stick to a pair of tweezers, if the technician is using those, or scissors, from someone shedding dead skin cells onto the evidence, from dandruff, from any number of things. So the problem comes when one has more than one sample and the amplification gets into the billions. We still have this same problem as you look at that. These charts, we expect to have testimony from the experts to address these charts. And we hopefully use these today to make this process a little clearer to you of how the PCR is amplified up, try and get some results. And even when you get the results, as I indicated this morning, a match doesn't mean like a fingerprint. It means consistent with generally. And there can be the contamination gets in there, then you can't tell one person's DNA from the other. And we can move on to the next chart. Now, In this case, to try and conclude our discussion of DNA so everybody can wake up again and be alive again, you've heard a lot about DNA, and you hear a lot about DNA evidence. The prosecution will undoubtedly present some of these technicians who come in from the crime lab who perform the various tests. And you'll recall that on this particular high-profile case, they designated as the officer in charge a Miss Mazzola, who was a trainee. This was only her third crime scene. And she was supervised by a Mr. Fung, who was a supervisor that day. And we expect their technicians will come in, tell you what they did, the various tests they conducted, and the conclusions which they have drawn from the tests. We expect to present testimony, however, somewhat contrary, including some of the people I've told you about earlier. And we expect that the people we call will tell you, based upon their observation and their knowledge of the field, which of these test results are reliable and which ones aren't, given what the technicians will tell you that they did. Now, in summary, with regard to the DNA, we will look at each item, hopefully have testimony regarding each item, hopefully have some testimony regarding which items are reliable or not reliable, and then give you evidence by which you can make a final decision. You'll recall, I believe, that Ms. Clark in her opening statement said that blood consistent with Nicole Brown and Ron Goldman was found on the glove that this Detective Furman we talked about claims to have found behind Mr. Simpson's home. That glove will be undoubtedly, the evidence will show, one of the most hotly disputed items in this case. Where the glove was, how it got there, where it came from, be very important issues. In addition to that, there will be a major dispute in certain other areas. I think you'll hear a lot of testimony about the so-called blood found in the Bronco. You remember the Bronco timeline. I think you'll hear a lot of testimony about whether or not the prosecution's contention that blood consistent with, not their blood, but consistent with Goldman and Nicole found inside Nicole Brown Simpson, inside the Bronco, whether or not this finding is trustworthy. We expect the evidence will show and that the police technicians would use unreliable procedures in collecting this. They made fundamental errors in conducting these tests, and then they misinterpreted their own findings, as I've indicated to you earlier. That the stains that they think are consistent with Goldman and Nicole Brown Simpson contain tiny amounts of DNA, so little can barely be detected. And this DNA could only be found using this super sensitive procedure we've talked about, where even a sneeze could contaminate it. So even if the test results were right, we think the evidence will show, the DNA could be from a tiny amount of contaminating DNA from the crime scene, from another person. Finally, in that connection, we think the evidence will show that the DNA results that supposedly put Nicole Brown Simpson and Ron Goldman in the Bronco are not like a fingerprint, and a match doesn't mean that. They detect characteristics in the DNA that millions of people have, not characteristics that are unique to one particular person. Now, let's talk about something other than DNA for a moment. When Mr. Simpson came back from Chicago, you think the evidence will be that he came home immediately, came back voluntarily after hearing about his ex-wife's death. You have heard some indication about his demeanor on his way back, that he came home, that he was asked by the police to come downtown, that he went downtown, that, without giving you what the statement was, that he cooperated fully, and that he gave the police a statement, perhaps some 33 minutes, which statement is tape recorded, that the two detectives who interviewed him at the time were Detectives Lang and Van Adder. He answered all their questions. Conclusion of that interview, they asked for a blood sample. Mr. Simpson was only too pleased or cooperative to go and give a blood sample at that time. And if I might step over a little closer, this next chart, and Mr. Douglas, what is this chart?
Number 205.
This chart hopefully will graphically illustrate what took place. Referring to number 205, we have Parker Center. This is the Los Angeles Police Department headquarters down at 150 North Los Angeles. This is the building in which Mr. Simpson gave this statement to the two lead detectives from robbery homicide. They questioned him and he answered their questions. Thereafter, and that's the building depicted, there's the little yellow circle depicted there. Thereafter, they asked Mr. Simpson to give some blood. The technician then drew some blood from his arm. We think, according to the testimony, it was approximately 8 milliliters of blood. What the testimony was between 7.9 and 8.1, which I think is 8 milliliters of blood. Now, we think the evidence will show under normal police procedures, they've been following their own procedures, when the detectives had this blood in a vial, certainly Mr. Simpson's blood at that time, they would have taken it over about a 3-minute or very short drive and book it at a place called Piper Tech. You hear evidence about where they book this kind of evidence, where the refrigerators are and that sort of thing. They book it to preserve it. You hear the importance of preserving that blood. We think the evidence in this case will show that the detectives didn't take the blood from Simpson at about 2:30 on June 13th, 1994. They didn't go this very short distance to Piper Tech and book it. For some reason, they came all the way, I guess this is some 20 miles or so, from downtown LA with the blood on their person in this vial, came all the way out here, this area called Brentwood, the home of O.J. Simpson, 360 North Rockingham Avenue. We think the evidence will show Detective Van Adder, who had this blood on his person, instead of booking it in Piper Tech where it should have been, carried this blood around from 2:30 till perhaps 5:20 in the afternoon on June 13th, 1994. Went back to O.J. Simpson's home. And there, we expect there will be some testimony. That blood vial he'd been carrying around apparently in his pocket, he then turned over to Mr. Fung, who was the supervisor of this officer in charge, the trainee at the scene. And then you'll hear some interesting testimony about what happens to that blood. The blood is supposed to be number 17, but it gets booked as number 18 at some point. Number 18 you're going to find is a pair of sneakers. That same afternoon at Rockingham, we think you'll hear testimony that Detective Van Adder's partner, Detective Lang, been with the LAPD some 25, 27 years, talks to Mr. Simpson after Mr. Simpson comes back home. And they ask him, what shoes were you wearing last night? Words to that effect. And they pick up a pair of Reebok tennis shoes. And I think you'll find that's consistent with what Cato Kalin had said he was wearing, I think, when he goes to McDonald's to get the hamburger. They then take these tennis shoes. Tennis shoes are ultimately booked as number 18. But for a while, at least, the blood is also number 18. Detective Lang, I think, will testify that he takes these tennis shoes, he takes them home for the night. He doesn't go back downtown and book them or whatever. He takes them home and brings them back the next day, which would be the 14th. So there's this mislabeling, there's this confusion as to what happens with this blood and who gets it. We know that the next morning, Fung has the blood downtown, and Colin Yamauchi, one of the technicians, takes 1 milliliter of blood out of this particular vial. So this blood, this is the strange saga of this blood and why it was carried out here. We expect the evidence will show exactly the events I've just testified to you, or just told you about in testimony. Mr. Douglas?
Next, Your Honor, is Exhibit 211.
Now, with regard to Exhibit 211, this exhibit seeks to demonstrate for you, as best we can, using the prosecution's records. All we can use is the records. These are their records. If this is wrong, maybe because the records are wrong. But the defendant's sample offered voluntarily. We've told you that. That's in Mr. Simpson's blood. I've already shared with you that you have 8 milliliters taken on June 13th. We know that the detective walks around with it for these 3 hours or so before the technician ever gets it. According to the records as we understand, so you start with the 8 milliliters. We know that on June 14th, we think there'll be testimony, that Colin Yamauchi took from phone 1 milliliter of Mr. Simpson's blood. We'll have to subtract that at some point. We know that 7 days later, Mr. Flaherty took 1.5 milliliters in a tube. It's a smaller tube, as indicated here. Ultimately, return 8 milliliters from this tube. So we know there was 0.7 milliliters used out of the smaller tube that had been taken on the 21st. Then on June 25th, Colin Yamauchi again put some blood on some threads for some purpose, and he used only 0.05 milliliters at that point, according to our understanding of their evidence. Then on June 27th, Mr. Matheson, again, another one of the technicians, took 0.75 milliliters of Mr. Simpson's blood, all from the same tube. And finally, the defense at some point were given 1 milliliter of the blood. We know that there's some blood left in the small tube, and we know that in a recent measurement in January, I think on or about January 4th of this year, there was 1.8 milliliters left in the tube, plus the 8 milliliters returned from the smaller tube. And if you subtract these particular figures, and I've done that, subtract the 1.0, the 0.7, the 0.05, the 0.75, the 1.0, you will have 3.50 milliliters of blood taken. To that, you have to add the 1.8 left, and the 0.8 that was used there are 2.60. So if you add the 2.60 to the 3.50, you will get 6.10 milliliters of blood. And so this chart, perhaps maybe it'll be explained to us during the trial, shows that if you started with 8.0 milliliters and you use 6.10 milliliters, there would be then 1.9 milliliters missing above the amount that's left, 1.90 missing. And one of the things we'll be looking at in this case is what happened to that missing blood, and where is it? Now, perhaps there are some records we haven't seen that will explain that. Those are the records as we understand it, that there would be 1.90 milliliters of missing blood in that connection. A bit more about this crime scene and what happened. We think you will see and hear from this trainee, Mazzola, and what she did at that scene, how she sought to collect these samples, Detective Fung's role at both Bundy and at both Rockingham. We think that you'll be able to then make a determination about what took place out there on that date. Now, one of the other key bits of evidence we expect in this case will be the socks that Ms. Clark talked to you about in her opening statement. You remember she talked about the socks? And I think that with regard to the socks, I believe we have a timeline and we also have a graphic with regard to the socks also. May we have the graphic and the number of the graphic? Okay. All right.
The graphic is D84.
D84? Thank you. You'll recall there was some testimony about this. I think there'll be testimony during the course of this case that this is the master bedroom in Mr. O.J. Simpson's home in Rockingham. There'll be testimony this place is usually meticulous and spotless. You'll note that the carpet is very, very light. I think there'll be testimony the carpet is either white or very light throughout, going up the stairways and in the hallways and various other places. And you'll recall that in this picture you'll notice that whatever the strap is on the bed is hanging down on the bed. I think there's another picture where that strap has been moved. And over in the center, and you'll see in this picture, the second picture, Mr. Harris, what is this? In this picture you don't see the strap hanging down, so apparently it's been moved. You will see a view of these socks. These socks apparently bald, kind of part of them rolled up, and on this carpet or rug that's at the foot of Mr. Simpson's bed and just in front of the fireplace. The only item you find there. Here's a close-up view of these socks, which were located there, and this now is June 13th, the afternoon hours at the Rockingham residence. These socks are located. Now, the timeline, I think, is helpful to us as we consider and look at these socks. Again, these socks were recovered on June 13th. Just talked about that. And they're examined on June 13th. There's no mention of blood on these socks on June 13th. We know that Michelle Kessler, basically the supervisor of the lab over there at LAPD, shows these socks, they can't really examine them, to two of our experts, Drs. Michael Baden and Dr. Barbara Wolf. They see the socks on June 24th. That's within 11 days of the socks having been taken back to the lab. It's June 24th. Around this same time, I think also in June, Miss Michelle Kessler, I think, makes some observations of these socks and at some point sees some fiber or something on the socks. So there's an opportunity, I believe the evidence will show, to look at these socks if we've been able to observe them on more than one occasion. Then we think that on June 29th, 1994, the evidence will show that Kessler, Matheson, and Yamauchi do in fact inspect the socks. There's a third date in the saga of the socks. It's not until August 4th, 1994, that anybody in the LAPD lab sees a blood stain on these socks for the first time. Now, these are the same socks that you see up here. They're picked up on June 13th. They're seen on the 13th, seen on the 24th, seen on the 29th, but yet it's August 4th before a blood stain is seen on these socks for the first time. And that's not all. We think the evidence will show that on or about September 22nd, 1994, there was, without testing any blame to anyone, a false leak to the press that Nicole Brown Simpson's DNA had been found on one of these socks. The problem with that false leak was that no DNA test had yet been performed. So they had predicted the results before the socks had ever been tested for DNA. They were still, in fact, at the LAPD lab, but they don't have the capacity to do this. Then the socks, after that leak, on the 22nd, I believe, and that leak was by a local Channel 4 reporter, who then reconfirmed that leak the next day about Nicole Brown Simpson's DNA on these socks. The socks then were not even sent out for DNA testing until September 26th, some 4 days later. Then, of course, lo and behold, on November 17, 1994, the lab reports they find DNA on the socks. Nicole Brown Simpson's DNA on the socks, just as they had predicted in this false leak back September 22nd. And of course, these are the same socks where nobody saw any blood at all until August 4th. And that's not all with regard to these socks. You will hear that throughout, there are very, very small amounts of these nanograms, which you saw on the chart, on the evidence in this case. The nanograms found on these socks is more than 1,400 nanograms, which is as much as all the other blood tested in this entire case, just on these socks. And so, we think this will be, the evidence will be, this will be a hotly contested item as to whether or not these socks were consciously, intentionally tampered with in an effort, in a rush to judgment, to get evidence on Mr. Simpson, where you have the results predicted before the socks are ever sent out to the lab. And the amount of this DNA being equal to the amount of all the rest of the blood found in this particular case. I think the evidence will show that in addition to this, you can see this area is very, very, very light around here. There's no blood found on this carpet or on that rug that's at the foot of his bed. That There's no blood found on the light carpet, on the stairs, in the hallway floor on the way up. Because the court has indicated, I believe, that we'll have a jury view in this case, you'll be able to see for yourself, hopefully, at some time in the near future, this particular area, you can see for yourself exactly how it looks and what took place. I should point out that the LAPD did, in fact, do some serology on these socks at some time, but they did not have the capacity to do the DNA that was predicted. So we think this will be something that you will find of some great amount of interest and will be a major item litigated during the course of this particular hearing. I mentioned to you earlier, as we leave the socks and what took place, that I wanted to briefly compare with you the conduct of O.J. Simpson with the conduct of the officers, the LAPD officers involved in this case for this general area of June 13th. Let's take, first of all, Mr. Simpson. We expect the evidence to show that Mr. Simpson's in Chicago on a prearranged, long-standing trip for Hertz to play golf. That he gets a call from Detective Phillips in the early morning hours. That his whole demeanor and everything changed, of course. That he comes back voluntarily. That when he gets back, he comes home. That he meets with the detectives. They ask him to come downtown. He goes downtown and he meets with the detectives without any counsel. That he talks with them. That he gives them blood. Does everything they ask of him. That he then comes back home that afternoon, June 13th, in the afternoon. Now, meanwhile, the detectives, we'll start with Detective Phillips, delayed, it's almost 10 hours before they get the coroner out there. And we've already talked about the ramifications of that and tried to establish this man's innocence. They then go from the Bundy crime scene to Rockingham. All four of them, as you know, then climb over the wall and they make these misrepresentations to the judge. So in their very first contact with the criminal justice system at 10:45 on June 13th, they don't tell the truth, the evidence will show. Because first of all, they know he's on a trip that was planned, and they say an unexpected trip. We've shown you those three items earlier. They don't tell the judge how they get over the wall or whatever. So these are the things they put in a declaration which you've previously seen already that day. They continue looking around, they amass and find evidence. We've talked already about how people at the scene, certainly at Bundy, are traipsing through the evidence and that sort of thing. They, later that day, after making contact with Mr. Simpson, are at his home. They go back downtown with him. They question him. They take his blood. Instead of taking his blood and booking it like they should have for their own procedures, they take that blood and come some 20 miles or so west, back to Rockingham, carry it around, seize his tennis shoes, don't book those until the next day, mislabel. The blood is to be 17, they label it 18. The tennis shoes or the sneakers are 18. And these are the experienced detectives in this case. When you look at this case, as the case progresses, we want you to characterize how they conducted themselves and how O.J. Simpson conducted himself in making a judgment in this case about whether or not the prosecution will ever prove this case beyond a reasonable doubt. There will be a number of key witnesses in the case. Without getting into any of them, all witnesses are important. I think all sides would agree that no side has a priority on the truth. All witnesses should be accorded, as the court has instructed you in looking at how you determine the truthfulness of a witness. You should do that. There are other miscellaneous points that I'd like to make at this point, with regard, one of which is with the 911 tape. The tape I have in mind now is the one from October 25th, 1993. I believe you heard testimony that one of the officers who came out at that particular time, and this is the time when many of you said during voir dire you'd heard this particular tape, when there's no physical injury or whatever, there's a door damage which is already damaged, which is damaged some more. Mr. Simpson agrees to fix that door. you'll hear what's on that tape with regard to what Mr. Simpson has to say and what Mrs. Simpson has to say about her intent and her thought. But I think what you'll find, the evidence will show that this argument, the entire argument on October 25th, 1993, was over picture frames of former lovers or lovers while they were away and separated from each other, not having been removed or taken out of the house as they were striving to get back together, as you know, during the latter part of 1993. In another area, in listening to the prosecution's opening statement, there was certainly a suggestion there may be some connection between the noises, these thumps on the wall, if you will, that were heard by Mr. Cato Kalin somewhere around 10:47 in the evening, and someone presumably climbing over the fence. His testimony, I think there's a fence back there near Cato's room, and accidentally dropping the glove where Detective Furman claims that he finds that glove, of course, later on in the morning. Keep in mind that there will be, we expect, testimony from Rosa Lopez about the fact that there are people and voices over in the Simpson compound, 12 o'clock on till about 3 o'clock, that she hears. It's not O.J. Simpson's voice out there. She hears people talking. She can't go to sleep, she says. We think the evidence will show that this walkway, which is very, very narrow, is very, very near where she lives, kind of in her housekeeper quarters in the house right next door. We expect the evidence to be that the area where Detective Furman claims that he found this particular glove is an area that has a number of cobwebs and things back there, which one might infer that people hadn't been walking back there, hadn't been back there for a while. I think the evidence will also show that on that side of Mr. Simpson's home, Mr. Simpson had wanted to come home and hide himself from anybody outside, a limousine driver. There are at least 2 entrances to his house on that side. There's one door the evidence will show that goes into a laundry room, and of course there's a door into the garage, all on this side of the house. I make these statements because I think this is what the evidence will show in response to what the prosecution has indicated. I think you'll also find that there will be testimony. There's a great amount of very thick shrubbery at the top of that fence that separates the property where Ms. Lopez lives, where Mr. Simpson lives on that date. And I think you'll hear testimony as to whether or not any of those twigs, leaves, or any of those items were ever disturbed or appeared to be disturbed, as though anybody had climbed over that fence. Now, we want to turn our attention to something I alluded to the last time. We call it the timeline. One of the things that we expect to show during the course of this trial is not only did Mr. Simpson not commit these brutal murders, but he did not, would not, could not, the time frame he committed these particular killings under the witnesses that both sides know about and we understand. What we have is a timeline with a chart and a timeline with the graphics, which we'd like to call to your attention now. So what's the number of that?
That is D87.
D87? And D87, so that you're clear, this is the Simpson compound. This is the home on Rockingham that you've heard a lot about. This street over here is the... Can I get that back? Thank you, Mr. Harris, sir. This street over here is the Ashford Street, where ultimately Allen Park will come. The street over here is the Rockingham gate, where the Bronco will be parked. There's a gate right here, and the Bronco is parked right there. Remember, we indicated there will be testimony about when the Bronco comes out, how it's a sharp turn right to that location. And over here, there'll be testimony that Cato Kalin's vehicle is parked. And in some of the subsequent photographs, I believe we'll see that his vehicle is parked here on Ashford also. Thank you, Mr. Harris.
D108A.
And this is the Bundy residence of Nicole Brown Simpson, and I believe that 875 Bundy is right there. This is the walkway that Detective Phillips talked about, right up in that way. A lot of shrubbery, and there's a gate there. The testimony was, you recall, or his statement was, you can see the bodies from the street. The gate was open. I think you saw some pictures when the prosecutors were doing their opening statement. This is Bundy, and Bundy in this area is a street that traverses north and south. North being this way, south being that way, west being here at the top, as I understand it. And this is the area here where these bodies were found. This is Nicole Brown Simpson's residence. It's the residence which she had purchased. You recall, with the funds that she'd gotten from the money that Mr. Simpson had given before he married, and then some additional funds that he'd given her. She had moved there voluntarily. And you heard the approximate distance between the two. What's your homework? Mr. Douglas, why don't you put yours up? Now, before we go into the timeline, we'll talk more about this, and you'll hear more about this when we discuss so-called alibi testimony. One of the things that I expect the evidence to show in this case is that Mr. Simpson does, in fact, have an alibi for his whereabouts on that particular night during the critical time. You'll recall that the prosecutors in their opening statement talked about the period of time between 9:45 and about 11. So our evidence here this afternoon will track that same period of time, 9:45 p.m. till about 11 o'clock p.m. And you'll recall the testimony that you've heard so far, that Ms. Nicole Brown Simpson spoke to her mother and an individual at the Mezzaluna restaurant, certainly in the area of 9:42 or thereabouts, had 2 phone calls in that period of time. So it's reasonable to assume that she certainly was alive at that particular point in time. So that's probably a very good starting point. What you have on the board, and this number, Mr. Douglas, what's his number again? 213. All right, this is 213. This is a view, a side-by-side view of each of these residences side by side. What we're going to do is we're going to start at 9:45, and in each instance for Rockingham and for Bundy, tell you what we expect the evidence to show of the various parties and where they were. Let's take the graphic on the board. And what's that number, Mr. Harrison?
D107.
Thank you. At 9:45, at the Rockingham residence, Mr. Simpson's, you'll see in this thing, we think the evidence is going to show that Cato Kalin is in his quarters, Mr. O.J. Simpson's in his quarters, and to the right here is Rosa Lopez. And you'll see this area. Let me just use this as an example. Hold it for him, Mr. Harrison. I think the evidence will show that the side of the house, Rosa Lopez lives right over in this part here, but there's this side of the house, a little walkway that goes right down the side of the house, back this way. That's where Detective Furman claims he found the glove in this very, very small area. It leads back out here somewhere. So at 9:45 at the Rockingham residence, you see the parties who are there. Mr. Douglas has charted that on the chart here. You can see it in both places. Mr. Harris, the next one.
D109.
All right, at 9:45 or thereabouts at Bundy, you'll recall this is the residence right there on Bundy, and we know from expected testimony to be that Mr. Cole Brown Simpson had a phone conversation with her mother and with somebody at the Mezzaluna restaurant about having the glasses which the party had left at Mezzaluna. We expect that she's still very much alive at that particular time. Mr. Harris?
D110.
We're taking this in 5-minute intervals, and obviously these intervals are this because you're doing it within 5 minutes. It's not exact, but it's as close as we can approximate based upon the evidence as we now understand it. At 9:50, parties in their same relative positions, Rosa Lopez, Mr. Simpson, Mr. Cato Kalin still in the side his residence. 9:50.
111.
Number 111, same situation with regard to Bundy.
D112.
9:55. Again, now keep in mind that the testimony will be that Rosa Lopez at about 8:15, between 8:15 and 8:30, has come out. She's seen this Bronco parked there. She's walked her dog somewhere back in this area over here that I'm indicating with the light, and she sees the Bronco kind of parked somewhat askew. And at 9:55, this is the relative positions that we think the evidence will show the parties at Rockingham at that time.
D113.
9:55, nothing else has changed at the Bundy scene at that point. Mr. Harris?
D114.
At 10 o'clock. This is at Rockingham, and at 10 o'clock, for your attention, I think you'll find there'll be testimony that the Bentley, of course, that Mr. Simpson and Mr. Cato Kalin had gone to get the McDonald's, the hamburgers in, parked in the yard there. That Cato Kalin is taking his food back to his room to eat. That they'd gone somewhere around 9 o'clock. They got back somewhere around 9:37 to 9:40, somewhere in that area. Bentley was parked. Mr. Simpson had eaten his hamburger. Rosa Lopez remains at the same place. We've drawn in, based upon what we expect the testimony to be, the car on the Ashford side here, the Cato Kalin's car. It's all in black there. And you see, of course, the Bronco. That's the 10 o'clock scene as we expect the evidence to show at Rockingham.
D115.
Now at Bundy, at 10 o'clock, we expect there will be testimony that a man named Tom Lang, same name as the detective in this case, but not the detective, a witness, we think will testify that he's out, as so many people in this neighborhood do, walking his dog down here. There's a street down here called Dorothy Street. There's this dog, and he's out walking the dog, and that he makes a statement to the police, which he tells the police that he sees a lady who fits the description of Nicole Brown Simpson wearing something, some kind of a black dress. The detective who takes the statement down, the evidence will show, miswrites it and puts it like a white flowing dress. But he tells him black dress, I think, the evidence will show. But he sees from this location down here, he sees this lady whom he believes is Nicole Brown Simpson, either touching or in some way embracing someone at a car parked at this curb, right about in this area here. And he is south of their location, and he sees a gentleman at the car, and he sees Mr. Nicole Brown Simpson. What he also sees, he sees a man he describes as a Hispanic gentleman standing on the sidewalk beyond where Mr. Nicole Brown Simpson and this gentleman are, and he is standing with his fist clutched, as I'm indicating for the record, staring down at Mr. Lang. And he thinks that this man may be angry with him because his dog is loose or whatever. So that's Mr. Lang, and that's 10 o'clock at that, and this is the residence here, that's 10 o'clock at the Bundy Street location. And if Mr. Lang, of course, is correct, and Nicole Brown Simpson is still alive, of course, at that point. At 10:05, at the Rockingham residence, Mr. Simpson has come outside the house. Mr. Simpson, I think the evidence will show at some point, made a telephone call somewhere between 10 and 10:05 to his then girlfriend Paula Barbieri on a portable phone that he'd had in this Bronco. There was a phone call. He was unable to hook up with her, but he did in fact make this phone call. I think there'll be records of whatever that affects. So at 10:05, that's the situation there with Cato Kalin still being in his room and Rosa Lopez still being at her location.
D116.
10:05, we still have the same situation at the Bundy location. We have Tom Lang, still at his same approximate location as we described. After making the phone call at the Rockingham location, we now have Mr. Simpson back inside. Mr. Simpson very often will swing golf clubs, which he keeps all over the place, in Bentley, in the garage or whatever, I think the evidence will be, and that he sometimes will chip. For you, those of you who are golfers, he'll chip or swing his 4-wood or 3-wood, generally over in this direction over here, where there's some sand where the kids can play and that sort of thing. But during this period of time, Mr. Simpson, at some point, swings his golf clubs or whatever, and at this point and later, chips, so he's out in this yard area after having made the call.
D118, D119.
10:10, not much happening at the Bundy that we can tell.
D120.
All right, after Mr. Simpson has done that and been outside, make his phone call, I think then you'll find the relative positions of the parties. Simpson back inside the residence. The evidence will be he's going to Chicago. At some point he has to pack, get ready. Cato Kalin's in his room. And Rosa Lopez still at her location at that point, although she's just about to leave.
D121.
Same situation at 10:15 on at the Bundy location.
D122.
This location at about 10:15 to 10:20, Rosa Lopez then comes outside of her location to walk her dog again. And she comes out in this general area to the right here on Rockingham. We expect the testimony to be that Rosa Lopez sees the Bronco still parked the same configuration, same location, just like she had seen it between 8:15 and 8:30. She sees it between 10:15, 10:20, the same location. And we think she'll also testify she saw this same Bronco parked in the same manner, same location, same configuration the next morning after she had talked with Detective Furman. That's Rosa Lopez at 10:20, thereabouts, at Rockingham.
D123.
At 10:20, contrary to what you've been told, I think, by the evidence by the prosecution that they can determine death by the plaintiff will of a dog, we have some live witnesses, Ellen Aronson and Dan Mandel. It's the two that I alluded to earlier who've been apparently on this date to Metzaluna, and they're walking home. They're walking down Bundy from north to south at about 10:20. They walk north to south in this location as I've indicated here. Thank you, Mr. Harris.
D124.
At the other location at about 10:25, we expect that Rosa Lopez at the Rockingham is certainly going back inside the residence now, having walked the dog. Mr. Simpson inside the residence, Cato Kalin inside the residence, and we have now for the first time the limousine driver, Alan Park, who comes up. And it's interesting, if you, can you back that up for a minute, Mr. Harris? Interesting at the 10:25 location, and you'll recall because I read you the testimony of Alan Park at both the preliminary hearing and the grand jury, that he didn't see or didn't look to see any other cars. Ms. Cato Kalin's car was there. He didn't look to see this Bronco was down there. And you will hear evidence, I'm sure, with regard to whether or not, what about the streets at that time of night, 10:25, 10:30 on a Sunday in Brentwood? What might you expect to hear? Were there lights on? What would be observable at that location? I believe, hopefully, we'll be able to go out to these scenes at night also. So we have Cato Kalin's car, Alan Park's limousine, and the relative positions of the other parties. We'll go now back to Bundy.
D125.
Now, by this time, according to what I expect the testimony to be, Ellen Aronson and Dan Mandel have continued walking south on Bundy, and now they are right in front of the residence there at Bundy. The importance of this, we think the evidence will show, that they walk there this very short distance, right to their right. If the crimes had occurred, would be these bodies with the gate open, with blood flowing down. If you remember when I read this morning from Phillips's transcript, when he was talking to the coroner about the need to come out there, these bodies are right there. They can be seen from the sidewalk or from the street. So these people are in a rather unique position. I believe that their testimony will be they saw no bodies, they saw no gate open at that point. It was approximately 10:25 when they're walking at this particular location. So that becomes, they become, as with all witnesses, very important. They become particularly important when the prosecution tries to present a theory that these killings had occurred at 10:15.
D126.
Back at 10:30, we have Rosa Lopez go back to her house. Everybody else in their same positions. Park is still out with the limousine. In fact, Park has at some point gotten outside the vehicle. If the testimony will be, and he's somewhere out here on the Ashford side of the residence.
D127.
10:30, I think we now have Robert Heidstra, who is in this alley. I described for you before an alley that runs parallel to Bundy, and this will be measured for the distance between this alley and Bundy there. But he also is out walking his dog on this Sunday evening. He's walking in this direction, again apparently from north to south. And it's about 10:30 that he first appears.
D128.
10:35, the situation is still pretty much the same at this point. The limousine driver is early. The roles of the various people appear approximately the same, 10:35.
D129.
10:35. Now you'll recall that Ellen Aronson and Dan Mandel have walked past this location at about 10:25. They don't see any bodies or gates or any blood. Now this man, Robert Heistra, is in this alleyway. I believe the testimony will be that at 10:35 or thereabouts, he hears some unusual things. He hears the sound, hey, hey, hey. He hears, I believe you'll hear, a gate clanging or closing. There will be testimony there are gates back this way at the Nicole Brown Simpson residence, in addition to the one in the front. That he hears the sound of men arguing. I believe that's what the testimony will be. So from this location, he can hear this. He hears this going on. He hears that to be at about 10:35 p.m. That's at the Bundy location. He's in the alleyway, and he's approximately parallel to the Bundy location, except he's in the alleyway off of Bundy. It's at 10:35.
E-130.
We know that according to the testimony of Mr. Park, at some point, about 10:40 or thereabouts, he pulls the limousine around. He's been trying to get contact with someone. He pulls around up to the Rockingham gate, which is on this side, as opposed to the Ashford gate, which is on this side, and then he apparently then goes back. You know, having heard his testimony read at both the preliminary hearing and the grand jury, got looking for and cannot tell us either way whether the Bronco is there or not. He goes back to this location, and that's about 10:40 or thereabouts at Rockingham.
E-131.
All right, 10:40, we have Mr. Heistra still in this alleyway, this area. This is approximately the time at 10:40 p.m., June 13th, that he hears this confrontation, supposedly with these men's voices, the sounds, etc., at the distance that he's away.
E-132.
All right, at 10:45, there'll be testimony, I believe, that Allen Park is up to the gate at this point, that you see the location of the other parties, their location. He's closer to the gate with the car right at the gate. You see the position of the other parties at that time. He's moved his car back from down at the Ashford gate back around. It's 10:45 or thereabouts.
E-133.
10:45. This is the journey of Mr. Heistra as he's continued down this alleyway. See where he's gotten now as he's walking the dogs. And he's still walking parallel to the residence, having made the observations that I've shared with you earlier.
E-134.
10:50 or thereabouts. Mr. Simpson, the evidence would show, has come outside of his residence. He's gone over to the Bentley at that point. Look inside the Bentley, and this location here, it's a white car, a white indication there. That's supposedly Bentley at that location. Simpson's outside the residence. Park is over at the gate. Lopez is back in her residence. Cato Kalin is still somewhere back in his quarters, apparently, at that point.
E-135.
10:50 now at the Bundy address. There are no witnesses at this particular point.
E-136.
Now, 10:55. We now have Mr. Simpson having been or done whatever he's doing in the area of the Bentley, going back over toward his house, to get his luggage and come down to get ready to leave. You have Cato Kalin coming out, presumably because he's heard whatever noises. He's now outside of the location. Allen Park is still over here. There's some testimony there'll be some golf clubs or whatever out here in this area of the yard in this area here. All at Rockingham. This is approximately 10:55, just before 11.
E-137.
The scene remains pretty much the same. Robert Heistra is now out of the scene here at Bundy.
E-138.
11 o'clock, Allen Park is let in. Your testimony, I think, will be that they start to load the limousine up, which is now inside here. Cato Kalin is having conversations with O.J. Simpson about noise that he's heard. He's trying to get a flashlight. He's trying to tell Mr. Simpson about what he thinks he's heard. Mr. Simpson is rushing around at this point. At some point, he goes back out. He goes to the Bronco at some point, comes back in, gets his luggage and brings his luggage down, a number of pieces of luggage, which you'll hear about. And all of these people are in and around 11 o'clock and thereabouts are in this particular area here, as depicted on this exhibit at Rockingham. Mr. Harris?
D-139.
Situation remains the same at Bundy. And so, at Bundy, no other witnesses at this point. Mr. Harris, will you go back to Rockingham at 11 o'clock? Cato Kalin's car remains in the same place. The limousine is now closer in the Ashford gate. Bentley is still where it is. Bronco is still where it is. Ms. Lopez is in her residence. Kalin, Mr. Simpson, at or around this area with Mr. Park. As I've indicated, this is the time that they're preparing to go on this pre-scheduled trip to the airport to go to Chicago. Around this time or thereabouts, Mr. Simpson's come out and gone out to the Bronco, and he comes back in also at that point. I've taken this from 9:45 until 11 o'clock because that's the time the prosecutor referred to and talked to, and I think it probably is the very appropriate time for us to look at. In discussing this particular timeline, I tried to demonstrate for you the witnesses that we expect will be called, what they have to say about this particular period of time. In listening to the prosecution's opening statement, they claim that Mr. Simpson left the Rockingham location, traveled to Bundy, killed 2 people with 1 knife, hid the bloody clothes, and returned to Rockingham. He did all this at about 10:15 or 10:15 and got back there at 10:25 or 10:30 or something of that nature. In a short period of time, that's what their theory was. We think that they have further, based upon their opening statement, committed themselves to a theory that in traveling to and from Bundy, Mr. Simpson had used this Bronco that you've heard so much about. So therefore, wherever that Bronco was that night, then according to their theory, that's where Mr. Simpson was that particular evening. What we tried to demonstrate for you in the evidence, we think will show, there's not that window of opportunity. There's not the time at which they can prove that Mr. Simpson committed these horrible crimes. They don't have the time, the opportunity, nor the motive to establish this. We think the evidence will show that he did not, could not, and would not committed these particular crimes. Now, in the course of this trial, you will hear some testimony regarding domestic discord, domestic violence, if you will, about what happened. I touched upon that briefly the other day. Without belaboring the point, and as you hear this testimony, I ask you, as with all of the evidence, to keep an open mind, to remember that the incident, January 1st, 1989, was the assaultive incident that Mr. Simpson took blame for, wrote letters of apology. And you recall the testimony we expect to be she was never struck after that in any physical sense, and that, in fact, he made an agreement regarding the prenuptial agreement, that if there was any physical touching, the prenuptial agreement would be voidable at any rate. That was never done. We expect to show that with regard to this entire domestic discord evidence, that there will be, and I ask you to bear in mind, in many instances where there are more than one person present, please keep an open mind until you've heard the other people who are also present at these incidents, so you can make a determination of whether this has any bearing at all. Because if you follow the evidence, and if you believe that Mr. Simpson could not have done this, that this timeline is such that there's no time for him to do it, no indication that he could have done this, that the Bronco was still there, whatever, then the character evidence would mean absolutely nothing. Because how could you then predict that someone who gets into a fight with his wife in 1989 will then kill her in 1994? One area that I did not cover earlier is the searching done in this case. They've searched everywhere in this case for weapons and or clothes, and I think the evidence will be that they searched even in Chicago, in the fields and the wooded areas in Chicago, all up and down Rockingham and Bundy and every place they possibly could. They worked very hard on this case because in their rush to judgment, they fixed on this one individual, and that's what they focused on, and we think the evidence will show that that's exactly what they did. Ms. Clark in her opening statement said that Mr. Simpson's time was unaccounted for, quote her, from 9:45 till 11. I think you'll find when you hear the evidence that he spoke to the police. This time is not unaccounted for. The time will be accounted for. That concludes your...
Now, why don't you approach the bench with the report, please?
Now, I think when we stopped, I was addressing the issue that we think the evidence will show that Mr. Simpson's time will be accounted for and not unaccounted during this particular period of 9:45 to 11 o'clock. In looking at my remarks the last time I spoke to you, I noticed that I misspoke when I said at one point that Dr. Kerry Mullis had won, I think I said, the Nobel Peace Prize, and I think I must have had Dr. Martin Luther King on the mind when I talked about him. He won the Nobel Prize for chemistry. I want to clear that up. When I was addressing you about the prosecution's theory a few moments ago in this case, I recall that Ms. Clark had indicated that the time of death was 10:15 based upon the whale of the dog. As to the time she alleges that Mr. Simpson got back to the premises, that'll be up to her to prove, and I suppose that I shouldn't speculate with regard to that. Now, I'd like now for Mr. Douglas to bring some charts up that relate to certain jury instructions, which I think would be very appropriate for you to have in mind, as with all of the jury instructions that the court has given you, with regard to the evidence in this case and how you're going to go about your task of rendering a decision now that you have an overview of this evidence. We'll have 4 charts that I'd like to step down. Yep. Now this chart is 2.20, which is the CalJIC, the jury instruction. I think you've already heard it. And the reason I wanted to point this out to you again is that as in this case, in all criminal cases, this is kind of a guide for you to look at the witnesses who get on the witness stand, to help you in determining whether or not you find that particular witness to be credible or believable, if you will. And they set out certain things that you might look at. Look at things like the ability of the witness to remember or to communicate any matter about which the witness has testified, the character and quality of the testimony of that particular witness, the demeanor, how that witness acts on the stand, and the manner of that testimony, the existence or non-existence of a bias. Does the witness have any interest or bias in this particular case? So the attitude of the witness toward this action will be things that you'll look at. And the court has read this to you in the character of the witness for honesty or truthfulness, or any statement previously made or whatever. These are the things that I would ask you to use with regard really to all witnesses called by prosecution or the defense. Remember that no side has a claim to the truth in this case as we go about this search for truth people have been talking about. The next jury instruction, and that is number, Mr. Douglas, number, get the number, Your Honor. Okay, like that, huh? Number 215. And number 215 is the so-called alibi instruction. And you'll recall that I asked you in voir dire a long time ago that you would not put any bad connotation on the term alibi if that's what the law calls it. That no matter who is charged with a particular offense, if you were someplace else, you produce evidence that you were someplace else, the law calls that an alibi. And essentially this instruction says that the defendant in this case actually will be introducing or expects to introduce evidence for the purpose of showing that he was not present at the time and place of the commission of the alleged crimes in this case for which he's here on trial. That if after consideration of all the evidence you have a reasonable doubt that the defendant was present at the time the crime was committed, you must find him not guilty. Now again, this instruction is important like all the rest. But the alibi instruction, if you establish the alibi to your satisfaction, be entitled to an acquittal under those circumstances. And I'd like you to think about that through the coming months as you listen to this evidence.
Exhibit 216.
Mr. Douglas? You recall all of the examples we used during voir dire again about direct and circumstantial evidence. Well, in the final analysis, this is a case that will rest primarily on circumstantial evidence, and you know what that evidence is. And there's a jury instruction that applies to that. It's extremely appropriate, and I think I applaud Judge Ito for having given you this instruction early on, because I think it's very, very important for you to be aware of this as you consider this evidence, especially circumstantial evidence, and how it will be applied at the very end of this particular case. This is part of that instruction, and the relevant portions would be as follows: that a finding of guilt as to any crime may not be based on circumstantial evidence. unless the proof circumstances are not only one, consistent with the theory that the defendant is guilty of the crime, but cannot be reconciled with any other rational conclusion. Further, each fact which is essential to complete a set of circumstances necessary to establish the defendant's guilt must be proved beyond a reasonable doubt. In other words, before an inference essential to establish guilt may be found to have been proved beyond a reasonable doubt, each fact or circumstance upon which such inference necessarily rests must be proved beyond a reasonable doubt. Also, if the circumstantial evidence as to any particular count, there are two counts here, is susceptible to two reasonable interpretations, one of which points to the defendant's guilt and the other to his innocence, you must adopt that interpretation which points to the defendant's innocence and reject that interpretation which points to his guilt. So after you listen to this evidence, as we think the evidence will show, and you have a belief that Mr. Simpson did not go back over to that location, didn't go to the location, that he was never, Bundy didn't, strike that his Bronco never left the premises that night based upon.
Your Honor, this is all argument.
Well, let me phrase it this way.
Please.
And the
Objection.
balance of the instruction is not ready to be read.
I'm going to get to that. If after you heard all the evidence, and you know what circumstantial evidence is, you will then be in a position to make a judgment as to whether it applies at this particular point. Without arguing what it is now, we'll have a chance to argue at a later time. But the point that I wanted to make at this point is for you to understand what this instruction would be as the court has. And lastly, as Mr. Clark points out, if on the other hand, one interpretation of such evidence appears to you to be reasonable and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. It seems reasonable, doesn't it? But the point is that you, no one else, will be the sole and exclusive judges of the facts and the weight of evidence. That's the determination that you must make. And no one can tell you what to make in that regard. And each of you in voir dire has promised to give us your individual opinion in doing that. And the last jury instruction is the so-called presumption of innocence, reasonable doubt, and burden of proof instruction. That's the last instruction I want to leave with you today. A defendant in a criminal action is presumed to be innocent until the contrary is proved. In the case of a reasonable doubt, whether his guilt is satisfactorily shown, he is entitled to a verdict of not guilty. And this presumption, of course, as you know, places upon the people the burden of proving him guilty beyond a reasonable doubt. And reasonable doubt has been defined as follows. It's not a mere possible imaginary doubt, because everything relating to human affairs, depending upon that everything relating to human affairs is open to some possible or imaginary doubt. It is that state of the case where after the entire comparison and consideration of all the evidence leaves the minds of the jurors in that condition that they cannot say, they feel an abiding conviction of the truth of the charge. Now that's what reasonable doubt is in this case, in every case. And I wanted to make sure that you again are aware of that as you listen to this case. This is a murder case with two charges, two counts. This is not a domestic violence case. Now, as we conclude, and finally, as I promised you today, I believe the evidence will show that we expect also that there will be evidence and testimony that a short time before Mr. Simpson went to Chicago on Sunday evening, June 12th, I think on or about June 2nd, his secretary, at his request, ordered the Star 69 feature at his request on his phone. And we expect there'll be additional testimony about that and as to why that was. In summary, as you then look at all the evidence in this case, we expect the evidence will show that O.J. Simpson, as you see him there, is not a perfect human being. He, like all of us, has made mistakes. Of course, we know there's only one perfect person who ever walked the earth. We think the evidence will show he's not guilty of these horrible crimes, that he has been blessed bountifully by God, and he shared his largesse and blessings with many, many people. That in this instance, prosecutors' theory that there was only one murderer is just theory. We expect to introduce evidence to show there was more than one killer, that the prosecutor's theory will be overcome by the facts which we present. We also expect that the evidence to show that the reason the prosecution maintains there's only one killer is that Mr. Simpson, whom they want to portray as a stalker, and stalkers don't come in pairs. There can only be one person under that scenario. That ex-husbands who are stalkers don't come in pairs, and that's why they're wedded to this one murderer theory, even contrary to what their own coroner may very well indicate. I've shared with you also the fact of Mr. Goldman's journey that evening, and when he checked out and went home and changed clothes and everything, so I will not belabor that. We expect there will be evidence about how you get into 875 South Bundy when one comes up and rings the bell or whatever, how you get in from the house or whether that's possible, whether somebody has to let you in or how you get in the particular residence. I've already told you we expect there will be evidence of the size of this area, and I think Ms. Clark has indicated, and I think the evidence will show, it's a very, very small area given the circumstances. We will show that the police who came over to Bundy, you will see walking through that scene, went in that house and didn't take one picture. They went in the house, that they found candles burning and various other things, that the investigation inside that house was shoddy and scarce, if at all, under the circumstances. And so in this case, as with many cases, you'll recall that we talked to you a lot about truth and your common sense. During voir dire, I think all of us told you that we wanted you to use your collective common sense. And don't leave it outside in the hallway, to bring it in and apply it to the facts of this particular case. And applying that common sense, as I indicated to you, you'll look and you'll be able to see this small area. You'll see the fight that Mr. Goldman put up. You'll see the injuries that he sustained. You hear the testimony about the amount of blood to be expected on the perpetrator. You've seen Mr. Simpson's body, the lack of scratches thereon. You'll see, and your common sense will address, based upon the evidence, the issue of whether one person could kill two people under these circumstances without hearing screaming and a lot of running and all sort of things. We expect, hopefully, that the evidence presented by the defense will help you provide some answers to these common sense questions. Expect also that you'll hear from a witness by the name of Paula Barbieri. She's, both sides are aware of it, and will testify about her relationship with Mr. O.J. Simpson. Specifically, as I mentioned earlier, between the period May of 1992 and May of 1993, and May of 1994 to the present. This case really boils down to a whodunit. That's what this case is about. It's not about domestic violence or whatever. It's about who killed these two people in these particular horrible crimes. The prosecution will probably start off with the domestic discord evidence. And that, with all the evidence, I ask you to keep an open mind. You know the circumstances. You know there are generally two sides to every situation. We cannot call our witnesses till we get our time in the part of the case where it's our time to put the witnesses on. That's why I've spent so much time in this opening statement, to try to detail for you what we expect the evidence to be and what we expect to show. You understand that the fact that someone has an altercation with one's wife in 1989 is not capable of being predicted whether that person will kill her, or be involved in any other fights, or whatever.
Sustained.
And so I started off by indicating to you that I thought this case would be a case where we would establish this as a rush to judgment by the prosecution. And they have theories and speculation. We would have the facts.
I assume these are the concluding remarks.
Yes, Your Honor.
Thank you.
Thank you. They would have theories and speculation, and we would have the facts. That I was trying to conclude what I was saying when she interrupted me. In this instance, in this case, both sides are interested in this search for truth. That's what a trial really is. It's a journey for truth, for you to determine the true facts what happened on June 12, 1994. We spent a great amount of time in selecting each of you for this task, because we knew it would be a very significant task. And in truth, I'm always reminded of something that James Russell Lowell said. The truth forever on the scaffold, wrong forever on the throne. Yet that scaffold sways the future, and beyond the dim unknown standeth God within the shadows, keeping watch above his own. And in this case, God knows what happened on June 12th.
Objection,
It's argument, all of it.
This
It's
is not argument, Your
It's a
Honor.
closing comment. Thank you, counsel.
Thank you. God knows what happened on June 12th, 1994. And we hope that after you've heard all the evidence in this case, you can make a rational decision, and you too will know what happened. And you will know that O.J. Simpson,
He can say that that's what he intends to prove, counsel. He can say that.
Thank you, Your Honor. And you will know that the evidence will show that O.J. Simpson, that man pictured over there on June 12th, did not kill his wife, did not kill Ron Goldman. And he is entitled to an acquittal. Thank you very much for your attention. Maybe the longest opening statement in the history of this building. But I appreciate your patience and the fact that you took the time to listen. Thank you.
All right, thank you, counsel. Deputy Magnera, we're going to take a break. Let me see counsel without the reporter before we do that. All right, ladies and gentlemen, we're at that part of the trial where we will now this afternoon start the presentation of the witnesses and evidence to you. As I mentioned to you, that before we actually started the presentation of the witnesses, we needed to do a little moving around of materials and things here in the courtroom. We're going to do that, and I expect to start with the witnesses in about half an hour. All right, so I'm going to excuse you to go back up to the lounge. Please remember my admonition to you. Don't discuss the case amongst yourselves, form any opinions. Don't talk to anybody about it. Let anybody talk to you. And we'll see you back here in about 30 minutes, right? All right, counsel, I'd like
He made other statements to other parties indicating that she had no awareness of any unusual events that transpired that night, and that her story was so incredible that when she attempted to sell it to the National Enquirer, they declined to print it. And that we would have told the jury about all of these things about these witnesses had we been informed.
So we're going to have a trial about the credibility of the National Enquirer?
No, we're going to have a trial about the credibility of witnesses who are so uncredible that even the National Enquirer would not use their story.
That's hard to believe.
It tells you how uncredible, but it certainly tells the court how uncredible that witness is, if even they decline to use it. And that we would have informed the jury of those witnesses and of those facts, but we were unable to do so because counsel willfully withheld them. Thirdly, with respect to the rheumatoid arthritis, the chronic and acute phases described by counsel, that again, these witnesses were not disclosed to us, and no statements were disclosed to us indicative of the possibility that they would be called for the purposes outlined by counsel. And had we known, we would have shown them the videotape of the workout tape made by the defendant 2 weeks before the murders, and we would like to show them some of the outtakes of that videotape. And finally, to correct counsel's entirely misrepresentative statements concerning the EAP markers on the victim's blood and victim's thigh and onto her nails. Counsel misrepresented the nature of the report to the jury in a manner that is so confusing and misleading that if we have to wait until that testimony is forthcoming, the jury will be hopelessly lost. The problem is that we have a diametric opposition between the report and what was actually said to the jury by Mr. Cochran. The report indicated that the B-type that came up on EAP marker was inconsistent with any of the three parties, and went on to state, which is what Mr. Cochran never let the jury know, that that did not rule out Nicole Simpson as a possible source, because her type being a BA, this is a very labile marker, which means that, in essence, the A falls off when there's degradation. That there was, in fact, evidence of degradation of this blood because her hand was found clutching her neck under her body where the blood was warm, very wet, and very subject to degradation in a rapid manner, which is what caused the degradation from BA to B, and that's what the report reflects. Moreover, counsel directly misrepresented the conclusion of the expert with respect to the blood on the thigh. That blood indicated a faint A activity. It was a faint A activity that is indicative of the possibility that it was her blood, it was consistent with her, and so the conclusion was inconclusive, not that it was not consistent with her at all. So right now the jury is sitting there having been totally misled as to the nature of the findings. Not only that, and misled as to the contents of the report because counsel excerpted portions unfairly. I understand counsel doesn't have to read the whole report, but it should be read with respect to all of the conclusions, not just the one that suits counsel with respect to this particular item of evidence, and that's what was unfair. We would ask leave of the court to inform the jury of the fact that they were misled, that the report actually states as follows, and to highlight all of the portions. At this point, Your Honor, counsel's statements to the jury have caused, because of the national televised nature of this trial, the whole country's been misled as to the truth. The truth has been hidden, has been obscured by counsel willfully. Counsel knows the truth. Counsel knows what we have in this blood. Counsel knows that the PGM subtyping has shown that it is her blood. And counsel knows that tests are ongoing that will further establish that it is her blood under her nails and on her thigh. But we have a whole nation now who has been misled as to the nature of this evidence. But more importantly, that this jury has been willfully misled and been made to believe that the conclusions were diametrically the opposite of what they really were. So we would ask leave of the court to address the jury with respect to that item as well.
Let me ask you this, Ms. Clark. Let's take it from the top. As to Ms. Gerchis, there is the claim of right to reopen since there was no notice given of this person's statement. This is the person who was alleged to have seen 4 individuals in the vicinity leaving the scene roughly at a time consistent with this particular crime, so obviously this is an important witness if this testimony pans out. What, in your offer of proof, do you believe shows lack of credibility and would be admissible as impeachment evidence? I mean, you've given me the fact that somebody has 34 pending lawsuits against them doesn't necessarily mean that they're not a credible person. I mean, they could be all car crashes for all we know. I don't know.
May I address the
I mean,
court?
other statements that are inconsistent, that sort of thing. I mean, that's a different issue. It has to go directly to credibility, other bad acts.
Mhm. Yes, I appreciate that, Your Honor. With respect to those lawsuits, we will be calling witnesses to testify to the fact that they were for fraud, which does go directly to credibility.
How many of these lawsuits are actually final with judgments rendered against Ms. Gerchis for fraud or fraudulent activity? Because I'm not willing to litigate 20 other lawsuits if there isn't some verdict in them.
We could simply call the parties to the lawsuit to indicate why they've sued her. They would indicate that, I believe with respect to almost all of these lawsuits we're talking about, all 34, they all deal with fraud and misrepresentations in the operation of her business. And
Well, do we know how many of these have resulted in verdicts?
I'm sorry? I can't hear you. Counsel's talking so loud.
Do we know how many of these cases have resulted in
May
adverse
I
verdicts?
may I
Certainly.
inquire, Your Honor?
Certainly. Judgments, verdicts, same thing.
We have,
Not for this purpose.
because counsel has hamstrung us by hiding this witness, we have not had a great deal of time to complete the investigation. And we have obtained a list of all of the, it's what Mr. Darden is holding right now, a list of all the filings that have been made against her, but we have to investigate each and every one to determine the resolution of each one. If counsel had given us this information in a timely fashion, Your Honor, I could have stood here before the court and explained and given the answers to all of this a long time ago. But it's been 7 months since they took the statement, and we just got the notion of her existence last week.
Well, Ms. Clark, then, since these revelations on Wednesday, you haven't sent a law clerk over to the Civil Index to go check the status of all these cases?
We are checking we are making checks on all of the representations of counsel. There is a lot to check, Your Honor. and with Rosa
Wouldn't you
Lopez
say-
as well.
Wouldn't you say this is a key, rather key place where you should focus your effort?
It's one of them, yes, and we have been. We have investigators out right now, and we have had. That is one of the many areas regarding Ms. Gerchis that we are investigating. But there's a lot to investigate in Ms. Gerchis, a lot. Not to mention the 3 Social Security numbers, the 3 phony names. Right in front of us, we have 4 judgments shown. And we have additional paperwork that we're going through upstairs as we speak.
So what are you asking for me to do? To delay these proceedings until you complete your investigation?
I don't think it's asking for very much to ask for some additional time to be able to present to the jury an opening statement that comprises all of the facts, since it is not our fault that we didn't have time to investigate this person.
All right, let me ask you about Rosa Lopez. My recollection is that her name does appear on the defense witness list and that you did have information regarding her previously, is that correct?
Yes, we had limited information regarding her. We have new representations made by counsel that indicate that there are other statements that we are not in possession of. The actual statement given to us by counsel indicates that what she told Detective Furman was that she heard some noises last night. That's all it says. Counsel made representations that she told Detective Furman that she was out at 10:15 and saw the Bronco on Rockingham, that she was out earlier at 8:30 and saw the Bronco on Rockingham, that Detective Furman was in possession of all of these facts and all of those details, when in fact their own witness statement indicates only that she told Detective Furman she heard some noises last night, period. No mention of a Bronco, no mention of being out walking her dog, no mention of seeing the Bronco anywhere.
When did you receive this
That statement?
statement?
September 1? So what counsel represented as having been stated by this witness to the jury is not at all what was contained in the witness statement that he gave to us.
All right, here's one of the difficulties, Ms. Clark. You're arguing Rosa Lopez. This is the first argument regarding Rosa Lopez from the prosecution point of view. She was not part of our discovery sanctions motion, to my recollection.
She
So,
wasn't.
She was not.
No, I know. I know, Your Honor. Yeah. We had to go through the transcript. You have to, Your Honor, when you tell us to go and do something, it doesn't just happen like that. We have to go up and we have to work. We have to go through the transcript. We were up all night.
Well, counsel, here's the
And
problem.
what we found is that when we went through the transcript, we found that there were many different statements attributed to her that we did not have.
Here's the problem. We took our recess to do that. I asked you to go through the record and find all of these discovery transgressions that you could find. The problem that the court has is I'm just the referee here. I'm not privy to what information either side has. You know the details of your case. You know what you have in discovery. I have no idea. I went through the record. I found the names of the 14 witnesses whose statements were given over last Wednesday. I went through the record and found the expert witnesses who were discussed that had not previously been disclosed, or it was unclear from the record who they were, and those that you objected to. Now you're raising an additional objection to Rosa Lopez that has not been litigated, and you're raising a different objection to the Mr. Cochran's statements regarding the EAP blood typing, correct?
Yes, well,
Neither of which was discussed previously in our sanctions motion, correct?
I did object on the blood before. I did. We went to sidebar, and I made an objection on the record to the court concerning the misleading nature of counsel's remarks. I'm on the record with respect to that, Your Honor, at sidebar. And
But see,
yeah.
part of the problem is that was part of our show and tell, where that was exhibited to you, and you had no objection to that exhibit. That's why I overruled your objection. There were 2 days where counsel exchanged exhibits, showed them to each other, And it was a little late in the middle of counsel's opening statement to then start lodging objections to an exhibit that both sides had seen and had waived any objection to.
I
That's
didn't,
the problem.
no, but I did not realize that counsel was going to excerpt a half of a sentence, which is what he did. I'd like to, if I may, Your Honor, I'd like to show the court what I'm talking about, because the court doesn't realize there's a paragraph. Counsel took out 2 lines from that paragraph, and it actually is, I think the court should see it, I really do. I think that if the court sees it, it will realize I was misled. I thought this entire paragraph was going to be shown. If it had been, I wouldn't have objected, but it wasn't. As a matter of fact, another thing that happened, Your Honor, was that I was shown the front page of the coroner's transcript, and I believed that that one area was going to be highlighted for the jury on that front page, and lo and behold, in front of the jury, I see counsel going after page after page after page, which I was not told about. I didn't bother to object because I didn't want to interrupt the opening statement any more than I needed to, but as a matter of fact, I was misled, both with respect to this and with respect to the coroner's report. Counsel put in a lot more, or in this case, a lot less, than what I was led to believe he was going to do.
Well, Ms. Clark, let me ask you this, though. After we spent 2 court days doing a show and tell, and you waived your objections, I mean, how am I supposed to go back and now revisit this and allow you to reopen opening statements? Because so far, the only thing that we've talked about that remotely approach being able to reopen on are your comments as to Ms. Gerchis, as to judgments against her, and the exercise video contravening the arthritis experts that had not been previously disclosed. But Rosa Lopez is an objection just now being raised, and the EAP is something, although you did raise that objection earlier, I think you waived that objection having passed on the exhibit.
I didn't pass on the exhibit, Your Honor. That's the problem. That's what I'm trying to explain to the court. Number one thing, let me get back to Rosa Lopez. As to Rosa Lopez, she was mentioned by counsel
No.
today.
If you're really
So-
worried about the EAP, let's quit jumping around. Tell me about the EAP and why you feel you were misled.
I think what the court doesn't remember is that we were supposed to have show and tell on Friday, and counsel only showed me a tenth of what they had. We came back in on Monday, and at the 11th hour, before we were to begin our opening statements, counsel sprung 20 new boards on us, and then pulled out the reports. Those reports were not shown to me on Friday. And to the extent that I was shown the reports, the coroner and this one, I was misled as to what they were going to use. And only when it was showing before the jury did I realize what he intended to do. I made the objection as timely as I possibly could. The moment he did it, I was overruled. Nevertheless, I was misled. And if I show the court how this paragraph appears, I think that the court will understand why I was misled. Counsel pointed to this portion of of one particular result on this page, and I believe that it was going to be fairly exhibited to the jury in context.
All right, why don't you read it for the record?
You know what? If I could use the Elmo, I can show it and read it at the same time.
By golly, let's do that.
The part that I've drawn, Your Honor, the bracket around, that's the item in issue. Item 84A. I need one. And 118A. Could not have come from Nicole Brown Simpson, Ronald Goldman, or O.J. Simpson. However, Nicole Brown Simpson cannot be excluded as a source of the stain if the EAP type B observed on the items were degraded from a type BA. Now, there will be substantial literature, Your Honor, to the effect that a type BA...
All right, let me see. Mr. Harris, is he available?
Your Honor, we went through all the laser discs, and we only had the highlighted portion that we show on 2 boards. One with the cover highlighted, and then pulling out the highlight. We only showed the laser board. All of our presentation was shown.
Your Honor, I don't even remember seeing a laser on this. All I remember having counsel tell me was showing me a report. You know, I would not have taken counsel to sidebar and objected to something had I known what he was going to do. As a matter of fact, I would have objected strenuously ahead of time had I realized that he was going to take one line out of context, outside of a paragraph.
All right, you understand the difficulty I have here. I mean, you've been given an opportunity to litigate it, and now you want to come back and do it again. That's my problem. Where's Mr. Harris?
I'll go back to the office, Your Honor.
Right to remain in the enclosure and it's private. We weren't saying anything about the laser disc would be used in reopening, should you permit it.
All right, Ms. Clark, there's really something that I can't deal with then if the laser disc itself, the exhibit that they showed you, is in fact gone, because I need to make a factual finding as to whether or not there was some, that you were misled in some way as to what it was.
I'll tell you, Your Honor, I don't recall seeing a laser disc.
Well,
There was,
Ms. Clark, let's look at the laser disc and see what's there, because that's pretty much frozen in its state. You know, that's not easy to manipulate, so let's take a look at it. Unfortunately, we probably won't be able to see it for quite some time. Since Mr. Harris is on his way, we'll have to catch him and bring him back.
But, Your Honor, I can represent to the court that we did not have the document here on Monday. We had only the laser disc, and the court required that we go through and show everything.
Which is
We
why,
have the document,
which is
show
why,
the document.
Mr. Douglas, I'd like to see the laser disc.
but why was it only being shown to us on Monday? Why wasn't it shown to us on Friday?
No.
No, I'm
Ms.
serious.
Clark.
You know something, Your Honor? This is very unfair. The defense was required to show all their exhibits to us on Friday, as we did for them. We sprung nothing on them. They came marching in Monday with twice as many exhibits as we were shown on Friday. We were expected to absorb everything in a nanosecond and come up with cogent objections to each and every item. And that's very unfair. The people were put at a great disadvantage at having to absorb a great deal in a very rapid amount of time and come up with an objection as to each and every item. I don't think it should be all that surprising that I couldn't remember seeing one of about 50 new exhibits that was thrown at me Monday morning before our opening statements were to begin. And that alone should cause the court to realize that the people were put at a disadvantage with respect to being able to make intelligent objections to all of the wealth of new information that was unjustifiably thrown at us at the 11th hour. We should be given more time at this point.
Did you ask for any additional time at that point?
I did, and the court was... I indicated to the court at the time, Your Honor, that I did not have an opportunity to examine it carefully, and you asked me to immediately go through board by board and exhibit by exhibit with about 10 seconds for each. There really was not a lot of time. The court is concerned, I understand, about having the time of the jury spent fruitfully, and I'm mindful of that, and I appreciate that. And the court, was feeling the time constraint, understandably so, and so was I. But the result of what has been misconduct by counsel in failing to turn over exhibits in a timely fashion should not inure to the people's detriment, as it has been. And I think that's very unfair.
So you're saying that last Monday, the 23rd, just so I can check the record if I have to. All right. I'm not going to take up that issue unless and until I see the actual Laserdisc exhibit, which has unfortunately left the courtroom. That leaves me with Gerchis and the arthritis experts.
Okay, and with respect to those witnesses, which the court knows we were not informed of, either their names or their statements or their proposed testimony, we would ask leave of the court to address the jury with respect to the fact that we were not apprised of their intention to call such witnesses to describe the defendant's physical condition at the time of the murders, and that had we known, we would have discussed that with the jury at greater length, putting on the exercise tape. Now, counsel showed us photographs of the defendant's body that they intended to introduce, but those photographs gave us absolutely no notice that they were going to be presenting testimony concerning rheumatoid arthritis. the existence of Howard Weitzman. That was another matter that was not turned over to us in discovery. The name was not even on a witness list. Had we known that they would make these representations to the jury that Mr. Weitzman was excluded from the conference room, we would have been able to address the jury on the fact that not only did that not happen, but the officers are very well aware that would be a violation of law. As a matter of fact, it's something that is contained in the Miranda advisement, that Mr. Weitzman was in fact pointedly invited in with Mr. Simpson, that he declined to remain with Mr. Simpson, and himself decided to leave the facility. And we would have told the jury all about that. We would have even maybe read the Miranda advisement to the jury so they can understand that this is an obligation of the police to afford anyone who appears with his attorney the right to have the attorney present during questioning, and that Mr. Simpson was so advised, and that he elected to proceed without the presence of his attorney, and we could have done all of that. But counsel, as a matter of fact, we have that waiver on tape. Counsel's aware of that. But yet counsel deliberately chose to make a statement that was false to this jury concerning Mr. Weitzman. Had we known he intended to do so, and had we known that Mr. Weitzman intended to so testify, we would have put that before the jury. Furthermore, all of the evidence with respect to the circle of benevolence, the charity, and the gift-giving, we had no discovery of any of that, Your Honor. That defense counsel wanted to present that. And with respect to at least the representation of anonymous gift-giving to links, we believe that we will have evidence to demonstrate that to the extent money was given, it was not anonymously given. And we would like to present to the jury the fact that the amount given to charity was minuscule compared to the amount of net worth this defendant had. And so we would like the opportunity to counter some of that evidence, which was also still has not been turned over in discovery. Still, only knowledge we have of that is the representations of counsel in his opening statement to the jury. Furthermore, with respect to Skip Taft, I believe counsel, again, this is another name that was not put on the defense witness list, for whom we have no statement, but counsel represented that Mr. Taft would testify concerning the contents of a prenuptial agreement.
Is there any dispute about that?
I believe there is. May I have a moment, Brad? There were certain representations made with respect to what Skip Taft would testify to in that prenuptial agreement, that he would testify to the circumstances surrounding it, and it was represented to this jury as being another act in the circle of benevolence, that in fact it was a civil compromise attempt and nothing more by the defendant in an effort to get to pressure Nicole to withdraw her support for the prosecution of that case. And we would like the opportunity to address the jury as to the truth of the circumstances under which it was written. I just can't, it doesn't come to mind at this moment. But that's for starters.
Mr. Bailey?
If it please the court, in asking this court to set what I think would be a precedent in criminal cases, the prosecution now wishes to escalate that remedy to a full-blown rebuttal of things they wish they thought of when they gave their opening statement. They knew before they opened that Mr. Simpson intended to exhibit his scarred and torn-up knee to the jury and claim that he was disabled to a degree. They had the exercise tape. They elected not to play it. Now, in retrospect, it seems a bad idea that they didn't. Since you have stricken from our opening the names and any summary of what they might say of the witnesses enumerated in your order, it seems to be most anomalous to silence us and let the prosecution get up and trash them without rebuttal, making wild statements like Rosa Lopez is an O.J. Simpson fan when she's never met him, or Nicole. Furthermore, all this claim of surprise on Rosa Lopez is totally incredible. You will recall that as part of our offer of proof in response to the government's demand to you, we cited two preliminary incidents, both occurring on the 13th, which showed bad faith on the part of Mark Furman. One was the glove, and the other was suppressing a statement that Rosa Lopez had given him. It was in the papers. It was faxed to the government on Sunday the 8th. It was argued orally here, and was in part, I guess, the basis for your ruling, together with the Anthony case. Mr. Cochran, long after the statement was taken and before this representation was made to the court, personally wanted to verify that she claimed that she had made those statements to Furman. And on that basis, we asserted it to Your Honor. I never heard it denied in the course of the whole argument. I don't think Rosa Lopez is any part of any reopening. Perhaps, perhaps as to Gertjes, if some admissible information can be gotten, the court might permit this now thoroughly trashed woman, who's never had a day to appear, although she's expressed an interest in doing that, to be impeached. If, in good faith, they claim, and they, as officers of court, assure you that they will produce on the witness stand, under oath, people who will testify that she has made the statements attributed to her. I'm not talking about judgments now or check cases. I'm talking about impeaching statements. If those representations can be made in good faith, perhaps, Your Honor, might permit them to talk about it. I haven't heard another thing in all of Mrs. Clark's presentation that makes any sense at all as reopening as a remedy for the sanctions, as part of the sanctions you've imposed. Insofar as the blood evidence is concerned, we have an assertion of fact, could not have come from Nicole Simpson, an attempt to bail out by somebody who obviously is in the prosecution's corner, speculating that if the blood were degraded, AB might have shown up as B, and therefore that would explain it without bringing in another party. We showed that on the screen. It's in the statement. If we had it to do all over again, I don't think any court could compel us to link the author's speculation with his established fact, and that's all that second sentence is. We pay it no importance at all, and we don't think that it's going to pan out. But in any event, in opening statement, we're entitled to show the jury those things that favor us. Now, apart from Ms. Gertjes, I don't believe Your Honor should permit any of what has been requested by the prosecution. It is nothing more than a chance to come back and rebut the defense opening statement. They could have handled all of these matters beforehand if they had thought about what they were doing as carefully as Mr. Cochran did when he laid out his very detailed presentation.
Ms. Clark?
With respect to the blood argument just given by Mr. Bailey, he demonstrates nothing but his ignorance. As a matter of fact, what Mr. Matheson put in that report is a matter of established science. We are talking here a matter that is the subject of treatises that are many years old. It is a known fact that the EAP marker is very labile, that a BA degrades to a B very rapidly, and the court can envision it. You have 4 bands in this marker: heavy band, faint band, heavy band, faint band. The faint bands are A, the heavy bands are B. The faint band, being A, degrades first. BA goes to B very rapidly. It's a known thing, which is why when there's evidence of degradation and you have a B result on the EAP, you cannot exclude the BA. And that is something that the jury has been completely misled about. Not to mention the fact that at least on the thigh marker, where counsel told the jury that it excluded her as well, there was faint A activity. So, I mean, there's been
I'm not prepared to really make a ruling as to the blood issue until I see the Laserdisc exhibit to see whether or not there is some real danger of the jury having been misled there. I'd like to hear your observations on Mr. Bailey's argument that you were aware that there was going to be some allegation that Mr. Simpson was unable to, because of his arthritic condition, unable to physically to even contemplate committing these acts. Why it didn't occur to you, knowing that, to play the exercise video during your opening.
When did we know that, Your Honor? When does counsel allege that we knew that?
When the motion was made for the defendant's right to address the jury during opening statement.
Which was on Monday.
Right.
Which we objected to.
Before your opening statement.
That's right, which we objected to. But being able to show a scar, which is what my argument was to the court at the time, has nothing to do with doctors who are going to testify to rheumatoid arthritis. There was no offer of proof forthcoming with respect to how that scar was going to be linked up. I repeatedly argued to the court, what is the probative value of showing the jury a scar? Believing that that's all that the defense would do, I elected at that time to let it be. Because I did not think that counsel, because counsel did not give us discovery. This is the problem with being sandbagged, Your Honor. Counsel never gave us discovery of the fact that the doctors were going to be rheumatoid arthritis specialists, were going to come forward and link up that scar to something meaningful in terms of his physical capabilities on that day. And counsel deliberately and willfully did not inform the court or the prosecution of his intent to link up that scar to a doctor's testimony. Now, how was I able to anticipate what counsel was going to do when he willfully withheld that information?
All right. Now, Ms. Clark, let me ask you one other thing. Can you make an offer of proof to the court that you will have witnesses, as to Ms. Gerchis, who will testify to inconsistent statements, such as telling other persons that she was truly not there, that she was not in fact looking for a condo or apartment in that area, any other specifics regarding credibility, specifically as it comes to this case?
Yes.
Tell me about that. You can make that representation that
Yes.
you will have those witnesses?
Yes.
All right, any further comment, Ms. Clark?
With respect to Rosa Lopez, I can only indicate, Your Honor, that we were unfortunately sandbagged badly in that respect as well. Upon reading the transcript, I was stunned to realize that counsel attributed many statements to her that allegedly were made to Detective Furman on the morning following the murders, when in fact his own statement indicates that all she said to Detective Furman was she heard noises. It took an extensive and exhaustive review of the transcript to realize, to go back to find exactly what those statements were. And counsel then reiterated it again today to this jury, which compounded the harm in his failure to turn over that report, which we still don't have.
All right.
We still have no statement indicating that.
Mr. Cochran, is there no report about that?
Absolutely none, Your Honor, if I might respond.
Then how do we know that then?
Because we went and talked to the witness, we talked to her, they had the report, when we got the report, Your Honor, they had this is a key witness, obviously. They know that she talked to Furman that morning. Don't they have an obligation, do we have to do their job also, Judge? Don't they have an obligation to talk to Rosa Lopez like I did? There's no further report. That's the thing that's so amazing about what they're saying. We don't have to do their investigation, Judge. We're the defense in this case. We don't have to do their investigation. This is unprecedented. We have them whining and moaning. These are just opening statements. We haven't even started the trial, Judge. And all this emotional, vitriolic, everything is misled, and everything they do is perfect, everything we do is wrong, and we are just doing our job, Judge. And it's absolutely incredible that she sees all these exhibits and all these things and wants to rehash everything with you, Your Honor. We offered that these things should be over at some point. We ruled on the other things. Yet we have to relitigate everything over and over and over again, Your Honor. And I don't think that's fair. It's not fair to Mr. Simpson.
You know, Your Honor, I'm appalled. You know, what does counsel think is his job, to mislead and to sandbag and to ignore the law and to flaunt the law?
All right, counsel, I'm just
Okay.
asking for, I just asked Mr. Cochran for an explanation. Is there a statement of Rosa Lopez that contains the, attributes to her the comments that Mr. Cochran made today and the day
Right.
before?
This
That
is
was
their
my
witness.
question.
Yeah, this is their witness. And when they take a further statement from a witness, they're obligated to turn that statement over, and as we always have. There have been multiple statements for some witnesses in our case, and the prosecution has never been derelict in its duty, has always fulfilled that duty to
All
turn
right.
all of them
Well,
over.
Ms. Clark, here's the problem. There's been a representation made to me that no such witness statement was taken. All right?
Nevertheless, obviously, the statements were made, weren't they? And we were given no notice of the fact that the witness made further statements that are of a much different nature.
When that witness is called, you may make a new objection, and I will contemplate precluding that witness from testifying, based upon the fact that it appears that at the time of opening statement, there was a clear intent to do that no statement was in existence, that additional statement was not disclosed. I've already made findings to other witnesses that this failure to disclose was intentional and deliberate. You can renew your motion then, but at this point, I'm not going to entertain any further sanction as to Rosa Lopez.
We would not ask the court to preclude her testimony, Your Honor. We would ask an admonition be given concerning her testimony.
All right. All right, court will rule as follows. The prosecution will be allowed to briefly reopen its opening statement. It will be allowed to go into inconsistent statements, specifically with regard to this case, regarding Mary Ann Gerchis. Prosecution, because the defense did not disclose the identity and nature of expert witnesses who would be testifying regarding arthritic condition, may merely say that now that we know that this is going to be an issue, we're going to show you this videotape or these outtakes. Prosecution may mention the fact that Howard Weitzman was having not been disclosed, that the information that you have, the evidence you will present, will be that that was not in fact what happened, that Mr. Weitzman was in fact allowed, or however you feel the evidence will come out as to that. As to the allegations of misleading the jury regarding the EAP blood types, I'm going to defer ruling on that until I've seen the laser disc. I'm going to sustain the court's own objection under 352, undue use of the court's time as to the circle of benevolence argument and the Taft prenuptial agreement, because I don't think there's any that's a matter of interpretation that can be done through the evidence and not through presentation of argument through opening statements. All right, and Ms. Clark, I'm going to give you a 10-minute time limit on that.
Very well, Your Honor, but we're going to need... I would like for the court to, I would like to await the presentation of the opening statement until we know the court's decision on the blood issue.
That's a much different issue. That doesn't go to sandbagging at discovery. That goes to the show and tell issue. That's a different issue.
But the resolution of it is the same, really.
Not really.
What other resolution could there be?
Well, that's a completely different issue that I'm not going to entertain until I see the laser disc. All right? But we have an hour left of court time. There are other sanctions that I can impose besides that, but I'm not convinced that a sanction is appropriate in that case.
With respect to that laser disc?
That's correct. I want to see the exhibit itself. If the exhibit, this is my thought on that. If the exhibit, although highlights one section, if the rest of the sentence is visible and there's a complete sentence available, that was exhibited for a long period of time in great detail to the jury. It may not have been misleading in that context. And Ms. Clark, please don't misunderstand me. I realize the pressures that you're under, both professionally and otherwise, and I really appreciate them. But at some point in time, when we have our show and tell and we make rulings and we agree not to, or we waive objection to things, that should be the end of it.
I appreciate that, Your Honor. I think that...
I agree with you, that's an important part. I agree with you, that's an important issue. But I need to see it before I can rule on it. I've given you something that's virtually unprecedented in any criminal case I've ever seen, the opportunity to reopen, but it's a sanction I think that's available to me within the spirit of 115. But those are the only three items that I'll allow you to reopen on. And you have a 10-minute time limit. All right, now, after we finish that, then what are you going to present? I understand there's a tape recording I need to listen to.
Yes.
What is that? Tape recording of what?
Let me defer.
Mr. Darden?
Doing that, Your Honor, two matters. We have not seen any video outtakes. We'd like to see them before the jury does. And I respectfully suggest, Your Honor, that you might wish to repeat the exhortations to counsel made on the opening day. I do not believe that personally directed epithets add any grace whatsoever to this proceeding.
I was actually, Mr. Bailey, I think I've spent a lot of time jumping on them today. So I was waiting for one of you to do that so I could jump on you to make the point, so.
Prefer the high road.
All right. I have to balance my excoriations from time to time.
You wanted some information?
Yes, Mr. Darden, what I'd like to know from you is you indicated to me at sidebar off the record that you were going to present apparently the audio tape of the 1989 or 1985 9/11 call.
Yeah, the 911 call from 1989. Yes.
1989.
Yes.
All right. And also you indicated that in the course of the reopened opening statement that you were going to present outtakes from an exercise video. Is that correct?
That's correct.
When did you receive those outtakes?
When did we receive the outtake? We received the outtake some days ago, and we pressed them onto a laser disc yesterday.
All right. Well, let's see what they are. Let's see what they are.
Also, there's a cut version of the Roy Firestone interview, which they have not seen,
It's called edited.
edited.
Anything else, Ron?
I advised Mr. Cochran of the Firestone interview editing earlier.
Mr. Bailey, you had a comment?
Yes, Your Honor. Mr. Cochran has suggested to me, and I endorse the notion, that in fairness to this witness who's been battered all over the courtroom for merely having the unpleasant experience of being a witness, that we might have a hearing on these alleged impeaching witnesses to see if they exist and what they really say before the jury is given that taint, which we can't undo for 3 months. Could they be brought in and appear before Your Honor just long enough to assure us that they exist and they have such testimony to give? Pretty good job has been done on Mary Ann Gersha so far. We're going to find our witnesses going to other countries pretty soon.
I'll think about that. But at this point, let me see these other items. Do we have the laser disc of the...
Yes, Your Honor. This is a full cube tape of the 10-minute segments of outtakes.
Before we play that, can we approach without the reporter for a moment?
Sure. Thank you, counsel. All right, I've been advised that the outtake material is still copyrighted material. So its release to the outside video feed will be interrupted for the playing of this item.
As I understand it, Your Honor, will last approximately 10 minutes.
All right, counsel, it's 10 minutes after 4 right now. I still need to hear the audio tape, still need to hear argument, et cetera, on that. I don't think we're going to finish with the jury today. My inclination is to send them home at this point.
As far as the audio tape is concerned, it's the same audio tape that I assume the court listened to back when we did the motion to eliminate regarding the DB.
Yeah, but by the time I finish watching 10 minutes of video outtakes, and if there's some objection to specifics, by the time we finish that argument, it'll be 4:30. You're ahead of the game right now, Mr. Darden, anyway. Deputy McNair, why don't you call up and let the jury loose for this afternoon? Thank you. All right, let's see the outtakes. All right, let's see that.
Actually, for that, I will need to change.
What's the copyright status of this material?
Your Honor, I'm not sure at this point in time.
Yeah. Ready? Sure.
On 3 occasions in the last 8 years, O.J. Simpson appeared on this program with me. A segment that originally aired in 1989. I asked Simpson about his pleading no contest to a charge of an assault on his wife, Nicole.
The day after this was over, we looked at each other and we had a fight. We were both guilty. No one was hurt. It was no big deal, and we got on with our life. As a matter of fact, after the Rose Bowl, we hosted a party for a great deal of amount of people, and mostly our friends. Took a trip with a couple of friends who never even knew we had an argument that night, and then 30 days later, I'm reading in the paper this major thing had happened, quoting things that people say to one another in the middle of an argument, right and wrong. I mean, it wasn't all right what you read in the paper, But it was embarrassing, but because our relationship was strong and all our friends knew it, and they knew what they were reading wasn't necessarily the truth, we just tried to put it behind us and ignore it as much as we could. We could have easily gone to court and been on the stand, and I think even the city attorney's office realized that they couldn't have won it, but that wasn't the point of filing. The point was to bring attention to a new law that's on the book, and who better to do that than me? And I just said, why me? Why am I the guy that you choose to do this? I don't think I'm a good example, and I don't think this incident this night was a good example of what you guys are trying to, bring to light.
That is the end of this particular segment.
All right. How long is the audio tape? I'm sorry?
I am removing the tape from a exhibit that has already been sent to court. It is tape labeled T55.
I should indicate that the dispatcher will be here to testify, and she will authenticate.
Your Honor, I'm not quite familiar with this new tape deck and the press sources.
Well, he's searching for the goods, Your Honor. What is this remedial to? Obviously, Mr. Darden could have played it in his opening, decided not to.
No, this is the, you objected, lodged some objection to this. This is part of our 402 hearing as to the tape.
Okay, this has nothing to do with reopening.
No, but I figured since we're here, we sent the jury home, we got all the equipment, we might as well listen to it all at one time.
Yes. He's going to listen to us at some point about the video and the other thing.
Is the Firestone tape also something coming into evidence, not for reopening?
Yes,
Okay.
correct. The only thing that we watched for the purpose of the reopening was the workout tape.
Fine. And as to that, I assume that if you permit them to describe it and show it reopening, it will be on a commitment that it will be introduced in the case in chief, and that it's admissible for all purposes and not some limited purpose.
I assume so.
All right.
Yes. Yes, they were.
Misplaced plug.
Proceed. A little more volume on that.
You calling from 360 North Rockingham, apartment number B?
Okay, please hold on.
So from Wilshire, Normandy at the highest. Suspect one is a male black, 5'10", 150 to 160, 25 years of age, wearing blue jeans, dark colored top. Suspect number 2 is a male black, 5'7" to 5'8", 150, also 25 years of age. Continuing wearing on dark clothing. Weapon used was .38 revolver. The vehicle suspect went in was going to be an 84 Buick blue. It's going to be one John.
Okay, let me give you this part. Wearing a gray sweater is shooting contact.
Hollow unit sending hollow units, screaming woman, 5514 service to Avenue Apartment 102, 5514 service to Avenue Apartment 112, female screaming for help, any hollow unit code 2 answer 1375 677. 7L40, I'll need to be 3A for my tow request.
Wilshire and Normandy at the Hyatt. Suspect described as a male black 5'10", 150 to 160, 25 years, wearing blue jean and a dark colored top. Number 2 is a male black 5'7", 5'8", 150, 25 years, wearing dark clothing. Weapon used is a .38 revolver. 911 emergency operator 74 Buick. License 1 John Adam Henry 129, 1 John Adam Henry 129, last seen westbound Wilshire. Harvey taken with $16.
7L40, disregard.
West LA and Cindy available West LA and Screaming Woman 360 North Rockingham Avenue, 360 North Rockingham Avenue, apartment number B. Female we heard screaming over the phone in West LA and code to high incident 1376 9813.
I don't know, sir. No, ma'am, why? What's the problem?
Apparently, turn the volume up during the middle of the screams initially. As I said, the dispatcher would be here to authenticate the tape.
Yeah, I couldn't tell what was the part they're trying to play. It's not clear.
You wanted to hear the tape.
Can we go back to what he's trying to actually tell the jury? It's not clear, Your Honor, what we heard all the
All right, well-
The whole thing?
Yeah.
Can you play that?
That was the whole thing.
There's actually, no, there is more. It relates to other calls.
In his opening statement, he said we were going to hear slaps.
You will.
And, I mean, I don't, who's going to identify and authenticate that? Who do they have that was there can identify and authenticate slaps?
The dispatcher. And if you listen to the tape, you can hear it too. And as I said, I think we turned the volume up during the middle of the screams.
Your Honor.
All right, well then, let me hear it from the top then, because that's all at the beginning of the tape.
So I would like to hear that again. Because
I'd like to-
The dispatcher tell us there's slaps. She can't do that.
Well, that's why we're having a 402 hearing, Mr. Cochran.
That's why we have a jury.
Yes,
Let
Your
the
Honor,
jury.
But no, but the point I'm trying to make. and
Oh, I understand the
forgetting,
point, counsel.
is that
Let's listen to the tape.
Yes. okay.
Some things are,
Did you hear the screaming though?
I didn't stand up and whine and moan when you made that statement, Your Honor.
Oh, I'm not
well,
whining and
now
moaning,
you're
Mr.
giving me the
Cochran.
opportunity. Gentlemen, really, this is getting out of control, and ladies, this is getting out of control going back and forth. You can make the same points, you don't have to engage in the personal invective. There's only one thing that really irritates me. I'm very patient, I let you guys talk a lot, but the thing that irritates me is the personal invective. All right, let's hear it from the top. I'm sorry? Okay.
Hello? You calling from 360 North Rockingham, apartment number B?
Let me ask you this, Mr. Darden, what generation tape is this? Is this a first generation off the large 24-hour reel-to-reel that LAPD has?
It's a second generation tape, I believe, off the reel-to-reel.
All right.
Shall I proceed?
Please.
Emergency operator 461. Hello? You calling from 360 North Rockingham, apartment number B?
All Art, thank you. I'm sorry? No, well, let me see everything that we got. Let's do all the show and tell, and then we'll take them one at a time. All right? Mr. Harris, so good of you to come back.
I should indicate that, we will, working with the controls, we'll filter out some of the noise, and you will hear, as the dispatcher heard just last week, as did other dispatchers here, as did I here, and as did other people in my office. You'll be able to hear them.
Counsel, we'll get to that. What I'm indicating, I want to see all the exhibits first. No, Mr. Harris is now here with our the famous laser disc. Let me know if you're going to bring up the victim's body again. And I hope the delay person caught that. All right, let me see the original, the full. Do you have the full report without the emphasized portion, Mr. Harris? No, that's... Okay. All right, counsel, just so we understand the parameters of what we're talking about here, as far as the question for reopening of opening statements by the prosecution, the issue was the court wanted to see the workout tape, so-called outtakes, that the prosecution wishes to present because the testimony regarding expert witnesses regarding the defendant's arthritic condition were not disclosed to them prior to the opening statements. Then also the prosecution wanted leave of the court to complete the pictures, quote unquote, as far as the EAP blood type. And I reviewed the exhibit just now. So let's settle the issue of reopening opening statements, and then I'll hear the 402 objections to the evidence. Ms. Clark, workout tape and the EAP item.
Workout tape was resolved
All right. Do you have anything else you want to say in support of the tape?
in support of the workout tape, Your Honor?
Yes.
Only, I think
All right. Mr. Carkin, those two items, Laserdisc and the workout tape.
Thank you, Your Honor. And I'll be very brief, Your Honor. With regard to the workout tape, I mean, we all saw the workout tape, and I think that I'll submit it, except to say that there was some moment of levity about giving your wife room or something like that. I don't know how that's relevant to anything at all. The latter part where Mr. Simpson is talking to the trainer apparently, and he's saying you have to give your wife room or something like that, or some statement when they're moving their arms. I don't know if the court noted that. I don't think that's relevant, and I think that could be ambiguous and misconstrued. Or you can turn the audio off at that point if you want to just show that. If the point is to show what he can do, why would you need the audio at that point? In addition to that, I still fail to understand what we said that would allow them to do this in a reopening, which is, the court has already said is so
Well-
unusual. Because let me add this one thing.
Sure.
As I indicated to the court before, one of the advantages, and I think this seems to get lost so very often here, that who would know better than O.J. Simpson that he has rheumatoid arthritis, in addition to the fact that we do have doctors who are treating him. But I'm saying that we would know that, and so I don't know how they're prejudiced, and I don't know how this tape helps with the rheumatoid arthritis. He talks about his knees, he talks about those things. So I just wanted to point that out. I think that if you do think that it's relevant and should be done, it seems to me that I think we're stretching it, number one, but secondly, any conversation with regard to your wife or giving your wife room or whatever that statement was, you may want to look at that again. I think that would be improper, ambiguous, and would not be appropriate to be shown to the jury. The other aspect you asked me to address was with regard to the EAP blood. As the court can see, in the show and tell, it's locked into the laser disc. We put the whole exhibit up, took out the portion, the court could see what we took out. That was shown to Ms. Clark, it was shown to everybody. This idea that they were rushing, well, that's not true at all. They were shown this, they looked at it, and with everything else, they continued to object. Even, to give you an example, Your Honor, this morning, Ms. Clark has this selective memory. She'd forgotten about the Furman thing. Out of abundance of precaution, I went back and told her again, Furman, she didn't recall that. You'll recall she argued about Van Adder, said we couldn't do that, and you'd already ruled on that. She will re-argue everything, and I think that's the point with his EAPB. We made that very clear, and it is absolutely outrageous for them to talk about misleading. We don't have to accept the fact that whenever anything points away from their theory of guilt towards innocence, and they want to talk about it being degraded, Your Honor, there'll be a lot of evidence about possible degrading. But that, again, that's their qualifier, that's their speculation. We don't have to accept that. We took the point that was made at that point, if the court pleases. And I think it's very abundantly clear.
All right.
First of all, with respect to the videotape, I think the statement that is made by Mr. Simpson is relevant and should be allowed to remain in.
Well, that goes to a different issue. You know, whether or not it's relevant to issues of domestic violence and flippant comments made about, spousal abuse, that's a different issue. You want to use it to reopen regarding arthritis. That's what you've asked for, not domestic violence. First segment deals with a workout. Second segment contains, I think, the comment, if I'm not mistaken.
Was it?
Since this is the first time I've seen it. All right, if the issue is the arthritis, at this time, I'm inclined to allow you to use the first segment only
For the presentation.
for the presentation. Now, when
Why
we
don't we
get,
just take the sound out? Since the issue is the arthritis for the opening. Wouldn't that resolve it?
right,
No, we don't want, no.
sure.
Absolutely not. Well, they want the sound out because he says, I've got these bad knees, you can't use these knees. I mean, what is this? I mean, I think that would be totally unfair.
First segment.
That's right. This is our case in chief, Your Honor. The council can put in whatever they want to put in when it's their
Ms.
turn.
Ms. Clark, here's the problem. Second segment clearly has problems with that statement. I'm not saying it's not coming in, but that's not the purpose you need it for the opening statement. All right? So you're asking for too much to get that in at this point. The first segment shows Mr. Simpson doing various exercises, stretching. He mentions the knees. That's what you need. That's what you want for your opening statement. That's what you can have.
Is the court requiring us to use sound?
That's what it is. You want a videotape, you take it the way it is.
Your Honor, if we don't want to use the sound, it's easy to take out. We can simply show
But
it.
then
That's how I saw it.
But then it's a misrepresentation of what's there, isn't it?
I'm sorry?
Then it's a misrepresentation as to what it is.
Kind of like what counsel did, you mean?
Do you want to use it or not? Yes or no? Use the videotape, don't use the videotape. It's up to you. First segment, that's all I'm going to allow in because that's all it's worth. All it goes to is the arthritic condition. Sure. Okay. Second thing is the EAP, the thing on the laser disc. I've seen it now. Any other comment?
I think the court can see how misleading it is. And I only wanted to indicate to the court that the defense violated the court order regarding a show and tell, showing up late with it on Monday. I do not recall having seen it, but we were hit with so much at the last minute, and as a result of the defense violation of the court's order as to when those exhibits were supposed to be shown to us, we were pressed into examining a huge number of exhibits, all at the last minute, with about seconds for each one. The result of a defense violation of a court order should not be that the people are under the gun and held their feet to the fire. That should not be the result. The people should be entitled to examine things in a more leisurely fashion. And the defense is simply pushing the court and pushing the court in order to get the court to push the prosecution unfairly in order to gain more tactical advantage, which is what they did exactly with the exhibits as well. It's a very consistent pattern here. We have a constant effort to sandbag and take the prosecution by surprise and try to make this a trial by ambush. They don't want the truth to come out. They want to put a stranglehold on us so that we cannot meet their evidence and meet their representations. And that's why everything is being hidden and popped out at the last minute. Too many last-minute surprises. And nobody's perfect, Your Honor. If we made a mistake, then I apologize to the court. That's what happens when people do things in a hurry. Mistakes get made.
Thank you, Ms. Clark. All right, the court's ruling, I'm sorry.
The court, this was argued on the 23rd. The court didn't even rule on this till the 24th, I think, you'll find the record will show.
All right, counsel, the court's ruling stands as to the prosecution motion to reopen. They will be allowed to reopen as to Ms. Gerchis. As to the inconsistent statements, they will be allowed to reopen to show the first segment of the workout videotape. They will be allowed to reopen as to Mr. Weitzman, since Mr. Weitzman was neither on the witness list or disclosed prior to the opening statements. I am going to sustain the objection to reopening as to the EAP blood type. All right, let's discuss then in the opening statement, the prosecution's first witnesses and evidence. Certainly. Clarification question?
Question,
Yes.
The question has to do with, the court indicated that he wasn't on the witness list or whatever. I'm indicating to the court he wasn't on the witness list, but for the prosecution to make this statement, I'm representing this court. Mr. Weitzman is going to say, along with Mr. Tapp, that he was asked to leave and was not allowed in that room.
And I assume that they're going to say that defense counsel made this representation to you. We're going to present witnesses who are going to tell you that that's not true. This is what our evidence is going to show, and that's all they're going to be able to say.
Okay, I just want to make sure, because Weitzman's going to, for allows, he's going to be coming in along with Skip Taft and others who are going to say what actually happened.
I suspect so.
Thank you. Just want to make sure that it's clear.
All right. No, it's crystal clear.
Okay, thank you.
All right. As to the Roy Firestone tape, any comment, Mr. Cochran?
Yes. We're now to the trial evidence, Your Honor.
That is correct. Two issues we're talking about here are the 9/11 tape and the Roy Firestone tape.
Well, let me then take, you asked me about Roy Firestone first. Let me take
Yes.
Roy Firestone first. It's a television interview, Your Honor, and I'm not clear for what purpose this is offered. It seems to me that if they're going to call Roy Firestone, I'm not sure they're calling Roy Firestone or they're just going to play the tape. Seems to me they'd have to call Roy Firestone as opposed to just playing the tape. Is there going to be a combination thereof? May I ask that question first? It has some relevance. You're just going to play a tape, and is that all that's going to happen?
I don't know. Mr. Darden?
Well, I think the tape is self-authenticating. I don't think I have to call Roy Firestone. It speaks for itself. Either that's O.J. Simpson or it's an imposter.
Well, the problem is, how do we cross-examine the tape? That tape is cut after an interview. When you go, the court's aware, when you do an interview, well, I shouldn't use that as an example, should I? Forgive me, Your Honor. When one does an interview, sometimes they last like 5 days or whatever. You know, let me tell you, Judge, they cut these interviews.
Oh, Mr. Cochran, you really know how to hurt a guy.
No, Your Honor, no. What the point I was trying to make, Your Honor, was that this interview is cut in a particular fashion to be shown over, let's say, a 22-minute period of time if he has a half-hour show. We can't cross-examine that. I'm sure that Mr. Simpson, as he sees that interview, will say, wait a minute, they cut this other part out that I said. If we have Roy Firestone, because otherwise it becomes hearsay, a form of hearsay. If we have Roy Firestone, I can ask him, well, didn't Mr. Simpson say so-and-so in addition to that? So we don't have that. So that's my first objection to this. I mean, I think that, again, as much what they do, it seems like it's much ado about nothing, but it seems that here's an interview in '89 where they're going to show the tape without Roy Firestone. And, Judge, I just think we'd be entitled to have Mr. Firestone as part of their case, because I think otherwise it's hearsay. I cannot cross-examine or show the circumstances of this particular tape. And I think that's unfair to the defendant. We're deprived of our constitutional right in that regard.
All right, what are your comments on the 9/11 tape?
The 9/11 tape, Your Honor, I was a little surprised to hear Mr. Darden say he's going to clean that up. Now, here we are.
I didn't say that.
I thought he said he was going to cut something out of it or do something out of it.
either.
He said something about doing, don't talk to me. Your Honor, I'm talking only to the court. I thought that Mr. Darden said something about cleaning something up or whatever. We don't want that tape altered. And I'm telling you, Your Honor, and I'm sure you've heard a lot of tapes in your life, and for him to have gotten up and said those were slaps, I think that that's going to be a major problem for him. I don't think that any dispatcher can talk about these being slaps. I think we have a further hearing regarding that person's qualifications. Based upon the tape that we've heard, I would ask the court whether or not this court is prepared to allow anybody to testify those are slaps. Certainly didn't sound that way to me.
All right, do you have any problem with the screaming woman in the background?
Well, I don't, no, I mean, if there's somebody who's screaming, if it's identified with this case, you say I have a problem with it. I'd rather not have that, of course, but I mean, I don't have a problem with it from a standpoint of their order of proof, if that's what they're trying to do. But he got up and told the jury they were going to prove slaps. I don't hear that. Then he tells us today the dispatcher can hear it, he can hear it, and he's going to do something with it to make it clear. And I don't think that's true at all. That's why we have these 4-3 hearings. So I do object based upon that, Your Honor. Until it's something that's relevant, it's something that's not speculative, and Your Honor, I want you to note that I'm not asking to reopen my opening statement so I can say that, gee, he misled this jury. Sometime or other we got to try this case, don't we?
Well, I hope so. Mr. Darden, let me ask you this. As to the Roy Firestone tape, I seem to recall that I sustained objections to the defense using a montage of videotapes, which I could tell were the crime scene at Bundy. I recognize the persons who were there, but we don't know where, when, how, and whether or not they're outtakes. And there's a foundational problem with it that the prosecution advanced, and I sustained that objection in your behalf. Mr. Cochran raises the same objection to the Firestone videotape. It is apparent who's there. It's Mr. Simpson, it's Mr. Firestone, and they're talking about the '89 incident. But there is still an authentication foundation that has to be laid. It is not inherently self-authenticating.
I think that it is, Your Honor. In discovery and during the DV hearing, I provided the court and counsel with a complete copy of the program, okay, and that is a portion of that program. And so whatever concern Mr. Cochran may have then regarding the authentication of that particular tape, there's no issue there. And you can't cross-examine a videotape. That's absolutely correct.
Well, here's the problem,
but he can't
Mr.
put
Darden.
on a defense.
There's an objection. There's a foundational objection is what I'm hearing from Mr. Cochran.
What is the objection? He has a complete program, and I want to play a portion of it. I have no duty to play the entire program, especially given the fact that it's not relevant to these proceedings. And so I want to play 4 minutes of that program that relates directly to an incident which the court has agreed is relevant and admissible in this case.
All right. Well, Mr. Darden, let's assume that I don't buy the argument that it's self-authenticating. Where does that leave us?
You're the judge. That's where it leaves us. I say it is. I say the evidence code would likely agree with me. I mean, it's a portion of a complete TV program which the court has seen, and which Mr. Cochran has seen.
I have the evidence code before me. You want to cite me to a code section that says that videotapes are self-authenticating?
No, I don't.
Well,
no,
I
I
mean, you put me in
I don't. But it's like any other writing. Okay, videotapes, like writings, can be self-authenticating. Okay, you have the date of the interview right there. We recognize the people in the videotape. They're identified in the videotape. Okay, we know the date that it was aired. We know it's an ESPN video.
Well, I agree with you. I know all these things. The problem is that they're objecting.
I'm helping them out. I'm trying to show them where they're wrong.
Okay.
Look at the videotape, the content of it. You want to know who produced it? You want to know the date of the interview? You want to know the subject matter? You want to know the name of the interviewer and the interviewee? It's all right there. What can be more authenticating than that? It's right there in front of us.
Well, isn't what's in there, the date on it, hearsay until somebody authenticates it?
No. Would it be in a letter? Couldn't the letter be self-authenticating? I mean,
Depends on what
does
the letter
someone have
is.
to come in and authenticate the date? I mean, the letter speaks for itself, just like the videotape speaks for itself.
But we just can't bring in letters. Somebody still has to testify who wrote it, whose handwriting it is.
Except that in this case, you don't need that because you see the faces of the persons who are speaking. You see the face of the person who is asking the questions. I mean, if you want someone from ESPN in here, fine, okay? I mean, that's fine. That's no problem.
No,
I'll get
it's
someone
not
from
me
ESPN.
who wants it. They're raising the
okay.
objection. I just as soon leave the ESPN people at home.
Sure, I'll get a clerk to come in and say, this is a program that aired at ESPN. This is a TV program. This is our videotape. It's a true copy. And that's that. And that's all that's required under the law.
All right, and what's your response to the screaming woman aspect, the slapping aspect of the screaming woman tape?
Well, I think that lay people can give their opinions. I'm not going to cut the tape or alter the tape so that you can hear slaps. I'm simply going to adjust the dials on the tape recorder here. If there are no slaps, the jury will figure that out. But let me add this. You have the tape of the screaming woman. You have the operator saying that the call originates from 360 North Rockingham, and you have her dispatching police cars to that location. You have officers arriving moments later. You have Nicole Brown Simpson, who has evidence, physical proof of having been slapped, plus you have her spontaneous statements. Okay. I think that when you look at the totality of the circumstances, I think, A, you're going to hear slaps as we adjust the knobs on the tape. But then again, there's also physical proof that the defendant slapped her, and he admitted it later on. I mean, he admitted harming her in his letters to her. So, what's the issue? What's the problem, Mr. Cochran?
All right, briefly.
Some of the problem is the evidence code is to the point. That's the problem. And hearsay and other things like that. I mean, it's not productive to tell you that you're going to hear slaps. He's told the jury that already. We've all heard this tape, and you're not going to hear slaps. It's a matter of interpretation. What I think we should make very clear, Your Honor, that counsel needs to read the evidence code with regard to that videotape and regarding, because there's analysis of that in the letter. That is not foundational, and I think we still have a problem. And I don't think you can just bring a clerk in here who is with an objective, brings a clerk in here to try to lay some foundation for this particular tape. As you correctly pointed out, Judge, when we were seeking to show a tape which everybody had seen at the scene, the court kept that out on various grounds, but it was a montage. These things are cut, pasted, put together, and it's a real problem if we don't have the person who did the cut and pasting. If we're talking about a truth and getting the facts out to the jurors, in which they claim they want to do. So I would reserve further objection. And I was reminded when I returned to my seat that what counsel had indicated was they were going to filter or something, use the words filter, with regard to this noise. We're entitled to have that tape just the way it is, not enhanced, and not just fiddling with the knobs, but the way we heard it here, not so they can bring up something to try to prove something. Further, there's a foundational problem with that tape. The address I think I heard was 360 Rockingham, apartment B. And there's no apartments at that location. There are no apartments at 360 Rockingham. I don't know, I'm not clear about what's happening with regard to that. But I think that there are some further foundational things, and I appreciate the court. That's why we have these hearings. But counsel has not given you asking for a case, asking for a cite with regard to the videotape, and you know the problems inherent with this tape. And this is just, they haven't even called their first witness yet, Judge, and these are the problems they're having with this evidence.
All right, thank you, counsel. Mr. Darden, I think you have I accept your offer of proof that you're going to have the dispatcher come in who was the person who took this call, correct?
Yes.
All right.
She will explain the B. I'm sure not to Mr. Cochran's satisfaction, but I'm sure to everybody else's.
All right.
And she will authenticate the tape. She'll also indicate that as she listened to the slaps and the beating, that she typed into her keyboard there contemporaneously the fact that she could hear the woman being beaten.
Is that part of our record of discovery? Has that been turned over to the defense?
Absolutely, Your Honor. Well, he should read his discovery
I've seen
then.
that, Your Honor.
He should read his discovery.
And I've not seen it. Furthermore, the fact
Well, he
that
hasn't
she-
read it. I'm at the,
I'm talking to Mr. Darden right now. Mr. Gargan.
Let's rest.
All right.
of course, it's part of the discovery, Your Honor.
All right. Mr. Darden, you're accepting your representation that you will have the dispatcher here who will authenticate the tape. I'm going to overrule the objection at this time.
Thank you.
However, the tape appears to me to be overly long because it goes on to other things and other incidents and other. How far into the tape do we get the actual dispatch of the unit?
That process, from the time that you hear the first scream until you hear the dispatcher notifying police
Any West
units.
LA unit,
Yeah.
360 North Rockingham, code
Yeah,
2.
right. It's
High.
about 3 minutes. And the problem here is that the dispatcher receives the call, she hears the screaming, and as I understand it, the line is left open. Okay. And so although you may hear other dispatchers coming on and dispatching other units to other locations and other matters, the line is left open and the dispatcher is still listening in.
All right, the
At
tape is
Rockingham.
relevant up until the point where the car is dispatched, but there's a lot of extraneous stuff that's going on there. So what I'm telling you, I'm going to let you play the first part of it up until the point we get to the actual dispatch of the car, because I think that pretty much ends the relevance of the tape.
So you're saying that once the cars are dispatched to Rockingham in the tape?
Right.
Oh, fine.
Question, Your Honor.
Yes.
Is the court allowing the dispatcher to say she heard slaps? I don't think we rejected that. I don't think you ruled on that yet. That's what, how is she able to make that determination?
Let's talk to her when she gets here, out of the presence.
They come forward there, well, I'd ask
Let's
counsel
see.
not to.
And Mr. Darden, why don't you pull up your, the sheet that you have on her notes, and we'll take a look at it tomorrow morning. All right?
Your Honor, when you hear that, who is slapping whom in that tape?
I don't know.
Looks like OJ was slapping. Looks like the defendant was slapping Nicole. I don't know. That may be the point in time when he grabbed her around her neck and left the hand in. I don't know.
All right, that's enough, counsel. All right, as to the Firestone tape, I'm going to sustain the foundational objection subject to further proof.
Thank you.
Okay, tomorrow morning then, so that we're clear, tomorrow morning at 9 a.m., the prosecution will have 10 minutes to briefly reopen their opening statements, then we will proceed to the presentation of evidence.
Portion of the
Yes, in addition to the
exercise.
4 minutes of videotape that's relevant. Mr. Bailey,
Go to the bench just for 1 minute before you.
do you want the reporter? All right, we'll recess 9 o'clock.
Before we do, I just wanted to...
I'm sorry. Ms.
Just for the
Clark?
record, I wanted to clarify the court's ruling. With respect to sustaining the defense objection to addressing the blood, is the court making a finding that the defense exhibit was not misleading?
No, I'm making a finding that we had 2 days of show and tell, that the prosecution has many lawyers available, at least two, perhaps three who were assigned to the blood evidence, that the purpose of the show and tell was for counsel to look at these things and to raise any objections. No objection was raised. It's too late at this point in time to ask to reopen as to that issue. That's the reason for the court's ruling.
But how would we have known that he was going
You're
to use...
just asking me for the ruling, counsel, not arguing. All right, I'll see counsel at sidebar.